Hi there. Hello. I am 13 minutes late. It's so nice to see everybody. I'm not muted. Can everybody hear me? Yay or nay? Actually. Hi. So we got Christine, Joanne, Yellow Jacket. Okay. So I want to show everybody something. It's not done. This is like probably the worst marketing strategy ever, but I'm a terrible YouTuber. So, but I want to show you, I figured I'm going to start our live with a video because, am I staticky? Ugh. Actually, okay, hold on 1 second. Did that help at all? Did that do anything? There's like a weird setting that I keep. Better or worse? Well, Joanna says I sound good, so. I have the air conditioning on, but the fan's not even. The fan is like silent. It's not better. Okay, hold on 1 second. How about now? Okay, well, I'm gonna fuck with the audio, but in the meantime, I'm gonna try and share this with you, so don't go away. Having had the state's motion in limine under advisement following a hearing conducted on August 1st, 2024, and having heard and considered the evidence, admitted exhibits, arguments of counsel, defendant's supplemental submission regarding state's motion in limine and the state's response to defendant's memorandum of law, grants paragraph 1 through 6 over defendant's objection, and grants paragraphs 8 through 12 over defendant's objection. As it relates to paragraph 7, the burden is on the defendant to show a nexus between Odinism, cult or ritualistic killing, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Ron Abrams, Kagan Klein, Jerry Klein, Ron Logan, and the murders of the two victims. The case law is quite clear that the nexus must not be based on speculation, conjecture, rumors, or hearsay, but rather on admissible evidence. The court finds the defense has failed to produce admissible evidence demonstrating a nexus between Odinism, cult or ritualistic killing, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Ron Abrams, Kagan Klein, Jerry Klein, Ron Logan, and the murders. Therefore, the court grants paragraph 7 of the state's motion in limine over defendant's objection. The court will not permit the evidence submitted by the defense in support of their arguments regarding third-party perpetrators in the trial of this cause, as the probative value of such evidence is greatly outweighed by confusion of the issues and its potential to mislead the jury. The court will allow that evidence to support an offer of proof at the trial if one is made by counsel. Jury selection will commence in Allen Superior Court October 14th, 2024. The trial commencing in the Carroll Circuit Court including November 15th, 2024. Paragraph 8 of the state's motion in limine reads, any reference to an investigation conducted by Todd Click, along with any reports or investigative materials from Click that are not relevant or used for the purpose of confusing the issues or has the potential to mislead the jury. Officer Todd Click's investigation into the Delphi murders paralleled and eventually merged with the investigation of Detectives Ferenczi and Murphy. It would be impossible to separate the investigative efforts and findings of these three law enforcement officers from one another. To exclude any reference to an investigation conducted by Todd Click is to wholly prohibit and erase the years-long dogged investigations of Detective Murphy and the late Detective Greg Ferenczi. Judge Gull's order granting the state's motion in full without citing any supporting case law and outright ignoring the mountains of evidence presented thus far in support of a third-party guilt defense all but guarantees that the trial of Richard Allen, set to commence on October 14th, will be exactly what we've all feared but entirely expected: a practice run. While Judge Gull's bias against the defense attorneys and her shameless, uncomfortable coddling in favor for the state should come as no surprise by now, it is perplexing that the special judge is so dismissive of the defense's theory of the crime as being ritualistic in nature. After all, Judge Gull's own chief public defender, William S. Labredo, who was in fact briefly appointed to defend Richard Allen after Judge Gull committed structural error and threw his defense attorneys off the case against his wishes, has spoken publicly to news and other media outlets about his belief that the Delphi murders were ritualistic in nature, and that Richard Allen is more likely than not a factually innocent man.
I thought it was hocus pocus. I honestly didn't, I'd never heard of it. And the more I got into it, that's a real thing. It is a real thing. And it's scary.
In what way?
Well, I believe they sacrificed a girl and killed another one. Some of the people that live in Delphi were very Odin beliefs on the Facebook pages, including the sergeant who was in charge of keeping Mr. Allen safe in Westville.
Sergeant Jones, who was wearing patches that said "In Odin We Trust" on his Department of Corrections uniform. Yep. The judge ordered the warden to make them stop. And then what did you notice?
That Mr. Jones had a tattooed under his right eye. From the best we can tell, it looks a lot like Odin's spear. And he had several tattoos on his forearms, including the interlocking triangles that are on his Facebook post. I got to give credit to Mr. Rosie and Mr. Baldwin that, they picked up on that. Confinement officers at the Allen County Jail aren't even allowed to have facial hair, let alone facial tattoos. I was a little miffed that the warden allowed that, or, he even knew what it was.
Do you have an opinion on that?
I do. I don't think Mr. Allen had anything to do with this. I honestly don't.
Is that something you say about all your clients?
No, and rarely do I believe it. But in this particular case, I believe it. 100%.
If an Odinism defense is good enough for Judge Gull's chief public defender, and it's good enough for three highly respected and decorated law enforcement investigators who pursued suspects associated with Odinism for over 2 years, and it's good enough for the FBI Behavioral Analysis Unit, and for academic and forensic experts of the highest caliber and credentials, what makes Judge Gull qualified to argue? The former prosecutor of Carroll County, Robert Ives, has also stated that he believes that there were signature, ritualistic, and non-secular components of the crime scene.
The crime scene is very unusual. It's all very strange. If you had arrived at this crime scene where the girls' bodies were found, there were 3 or 4 physical characteristics of the crime scene that you absolutely would take pictures of. I hope that people who are handling the investigation will consider whether perhaps it might be time to release some more of that information. In the early days of this investigation, law enforcement, the FBI, the Indiana State Police, the Carroll County Sheriff's Department were looking for crimes in other locations that might have similar characteristics. And even then, the characteristics they were looking for tended to be more general things than the items I'm talking about, but they are very unusual.
You were quoted as saying that the evidence or the crime scene was odd. What do you mean by odd?
It was just not your normal, a person was killed here crime scene. There was a lot more physical evidence than that at the crime scene. And it's probably not what you would imagine, where people think that I'm talking about. And so because of unique circumstances, which all unique circumstances of a crime are a sort of signature, well, this unusual fact might lead to somebody, or that unusual fact might lead to somebody, where sometimes criminals will commit a crime in such a way that it's so distinct that it acts as a sort of signature for them.
Was there a signature to this crime?
I would say there were 2 or 3 things. I'd say at least 3.
Do you think those signature items would still exist?
I think potentially that 1 or 2 of those things could pop up again, yes.
On July 7, 2021, at approximately 2:15 p.m., Detective Greg Ferenczi was shot and killed outside of the FBI Indianapolis resident agency in Terre Haute. A subject drove to the gate of the building and threw a Molotov cocktail at it. The man then confronted Detective Ferenczi and shot him as he came out of the building. Despite being wounded, Detective Ferenczi was able to return fire. An FBI agent also rushed outside and shot the subject, who then drove himself to a local hospital, where he was taken into custody. The subject was subsequently charged with the murder of a federal agent. As a pillar among law enforcement and citizens alike, the senseless, tragic loss of Detective Ferenczi shook the community of Terre Haute and beyond.
This is a federal case. The FBI will have the lead. Greg Ferenczi was a good man, a 30-year member of Terre Haute PD, and worked in this community for many, many, many years. It's a sad day for this community and for the Terre Haute Police Department.
Greg was a 30-year veteran of the Terre Haute Police Department, but he was also one of us, a member of the FBI family. For 11 years, Greg served as a task force officer, later joined our Indianapolis Joint Terrorism Task Force. And to his FBI teammates, Greg was the guy. Greg was whip smart. His coworkers labeled him a secret genius. He was a terrorism expert working in the middle of the Midwest. Greg brought decades of investigative experience, invaluable wisdom, and life lessons.
The murders of Abigail Williams and Liberty German were the result of hatred. Hatred for women, perhaps. Hatred for race traitors. Hatred for the privileged, the elite, the other. But where judges are called upon to serve as a balanced, fair, and impartial foundation upon which justice may be carried out, Special Judge Frances Gull has allowed hatred to consume her. Hatred for the defense attorneys who were willful and insubordinate, who humiliated her in front of her colleagues and superiors. Hatred for her own shortcomings, her own inability to occupy a seat which she has claimed as rightfully hers. Hatred for a defendant who has yet to be tried, and despite his fundamental rights to due process and his total presumption of innocence, the special judge held him in maximum security prison in total isolation and torment for over a year. Judge Frances Gull is on a mission. It's a mission she shares with the Unified Command Task Force, with Lieutenant Jerry Holman, with Detective Tony Liggett, with Prosecutor Nick McClelland, Superintendent Doug Carter. Judge Gull is complicit in the conspiracy to convict Richard Allen. We are watching the state of Indiana hang a constitutionally innocent man. The fix is in. And while the state of Indiana conspires to convict Richard Allen, the person or persons who murdered Abby and Libby are free. Okay. Thank y'all for watching that with me. It's not done yet, but I will share it after we get off. But the case moves very fast, so sometimes you like make a thing and then it's like, I should, you know, you gotta get it out because otherwise it's not gonna be relevant. Like, here's hoping Judge Gall gets shit canned. But anyway, we are here because the defense representing constitutionally innocent Richard Allen has filed a thingy, as my friend Michael Osbrook would say. They have filed a thingy and we are going to read it. Yeah. Can we see this? Oh, that's so nice. Thank you. Yellow. I'm gonna buy her a $10 something later. We're just gonna go back and forth until we die together. Okay. Oops. So this is a motion for the court to certify. Okay, I need to close the chat so I don't get distracted. All right. So we've got a motion for the court to certify court orders for interlocutory appeal pursuant to Appellate Rule 14 and request to rule expeditiously on said motion. Comes now the accused, Richard Allen, by and through counsel, and moves this court, Judge Gall, to certify the September 4th, 2024 court order granting the state's motion that prevents the defense from presenting certain evidence, and the August 28th, 2024 order denying the defense's motion to suppress certain statements made by Richard Allen for interlocutory appeal pursuant to Indiana Rule of Appellate Procedure 14. Furthermore, the defense would request this court to rule expeditiously based upon the October 14th trial date. In support of this motion, defendant Richard Allen states the following. Number one, the Indiana Supreme Court has recognized that orders in limine have historically been eligible for interlocutory review. Orders in limine are eligible for discretionary interlocutory appeal. They are eligible for appellate review under Appellate Rule 14b to the same extent and with the same prerequisites: trial court certification and Court of Appeals acceptance as any other interlocutory order. The tentative nature of orders in limine does not result in the categorical exclusion of those orders from discretionary interlocutory review, which is why our appellate courts have long reviewed orders in limine through interlocutory appeals. Number two, in the past, interlocutory appeals concerning motions in limine have also been allowed to the benefit of the prosecution. In State versus Harold Lewis, after the trial court granted the defendant's motion in limine, the state of Indiana received an order in limine preventing the prosecution from presenting certain evidence. The trial court then certified the order for interlocutory appeal, and the Court of Appeals accepted the order for interlocutory review, ultimately reversing the trial court's ruling. So the state can also request interlocutory review.
Don't know why they can, but they can, and that's cool. The denials of motions to suppress are also eligible for interlocutory appellate review. Direct review of the denial of a motion to suppress is only proper when the defendant files an interlocutory appeal. Number 4. Damn me. The defense contends that the court's September 4th, 2024 order denied Richard Allen's right to present a defense in violation of the Sixth Amendment of the United States Constitution. Hard to argue. 5. Furthermore, the defense contends that the court's September 4th, 2024 order denied Richard Allen his constitutional rights to the following provisions of the Indiana Constitution. And I will pull up the September 4th order after this. It's the one that it's not the one we read together. It's, well, I don't even fucking remember, but I'll pull it up after. Section 12. All courts shall be open, and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. They clapped. Section 13A. In all criminal prosecutions, the accused shall have the right to a public trial by an impartial jury in the county in which the offense shall have been committed, to be heard by himself and counsel, to demand the nature and cause of the accusation against him, and to have a copy thereof, to meet the witnesses face to face, and to have compulsory process for obtaining witnesses in his favor. Section 19. In all criminal cases whatever, the jury shall have the right to determine the law and the facts. Oh, it's almost like the judge can't put her opinion in an order and say that it's Bible truth. Interesting. Where did I leave off? I started clapping, I got lost. Oh, 6. Furthermore. Yes. I haven't actually read this yet, so until now. Furthermore, as to the alleged confessions of defendant Allen, the defense contends that the court's August 28th, 2024 order denied defendant Allen his 5th, 6th, and 14th Amendment rights under the U.S. Constitution, as well as his constitutional rights under Article 1, Section 12, 13, and 14 of the Indiana Constitution. Because we know Judge Gull is like, you didn't have any Indiana law? Michael, I would love to have you on. I will send you a link as soon as I'm done. I would absolutely love that because I am just dying to hear your legal analysis and also your snark. If this court has erred and the determination of the error is withheld until after judgment, then the appellant, victims' families, and citizens of Carroll County will suffer substantial expense and damage as follows. Richard Allen will suffer continued incarceration while awaiting the ruling from the Court of Appeals. We know that to be true. B. If Richard Allen is convicted without interlocutory appeal, then he, as well as the families of the victims, would first suffer through the anticipation of a ruling from the Court of Appeals or Supreme Court on these critical issues, and then whether a reversal will result in a second lengthy trial. If the appeal in regular course, not interlocutory, results in reversal, then Richard Allen and the victims' families will have to endure a second lengthy trial. Not ideal. C. Also, the poor taxpayers of Carroll County will suffer substantial cost. More substantial cost. Perhaps in the millions of dollars between appellate costs, attorney's fees, expert costs, and cost for security in 2 different counties based upon a second trial, as well as time of all the parties involved, including the trial judge, prosecutors, defense attorneys, law enforcement, family of the victims, and others who will sit through a second lengthy trial. Additional costs associated with sequestering a jury during a second trial will also be significant in both expense and time. D. Moreover, the prosecution of defendant Allen has brought about worldwide attention in nearly every form of media coverage, as well as extensive coverage by various social media platforms. What's that? The disclosure of facts and information, including many facts unknown to the public, even to this day, at a jury trial will result in the consumption of this information by these reporting sources. Notice they don't criticize the media for reporting as the media. Notice they don't criticize social media for reporting. Instead, they just say, oh my God, they're going to report on it when we go to trial. Not a bad thought. The dissemination of this information to the public, which will undoubtedly occur, will make it more difficult for Allen to find unbiased jurors in the event of a retrial. Totally. E. Wow. Defendant Allen's detention circumstances are unlike any other pretrial detainee, perhaps in the history of this state. He has been, and continues to be, isolated from any sense of normal contact with the outside world, with the exception of his ability to make monitored phone calls to his family. This has been the case for nearly 2 years. To the extent a retrial would occur, Defendant Allen's detention circumstances would place further burdens on him and the facility in which he's housed. This workload would be compounded and would likely require months and months to organize, review, and prepare for a second trial. Really good point. If a second trial were to occur, the compounding of discovery, transcripts, and other related materials stemming from this case would place extraordinary burdens on the state, defense, victims' families, defendant and defendant family, and not to mention the judge and court staff members in both Allen County and Carroll County. Law enforcement officers from the various investigating agencies would be required to continue to exhaust their time and resources, even beyond the 7 years that have already passed since the crimes were committed. And finally, the additional expenses to be borne by the taxpayers of Carroll County would continue to mount. It is for these reasons that an interlocutory appeal addressing the issues of Defendant Allen's pretrial detention and incriminating statements allegedly made by him thereafter is appropriate. H. Additionally, should this court not allow these issues to be heard by the Court of Appeals in an interlocutory fashion, then during the jury trial, set to begin October 14th, the jury will be sitting for hours, perhaps even days, while the defense presents its evidence in an offer of proof. We gonna go there, Gull. We are gonna go there in your 30-day no-exception trial. Whereas, should the Court of Appeals find that the trial court was in error, then the jury would not be forced to wait outside the courtroom or in their hotel rooms for hours or even days while the defense presents its offer of proof. They said, we're gonna do it, and we're gonna do it, and we're gonna do it for a long time. The trial will run more efficiently and at less expense should these issues be resolved by the Court of Appeals before any trial takes place. 8. This court's August 28th order and September 4th order both involve substantial questions of law, and the early determination of those issues will promote a more orderly disposition of the case, to wit. In bold, the September 4th order denies Richard Allen the ability to present a defense, violating both state and federal constitutions. Oh, good. On September 18th, 2023, the defense filed its first Frank's notice, at which time the defense revealed in great detail its defense that Odinism and Norse paganism explained the unusual nature of the crime scene, and furthermore identified particular suspects who were tied to the victims and or the crime scene. 10. That September 18th, 2023 Frank's notice was very transparent and left no doubt that the defense would be claiming that A. Odinism, Norse paganists were involved in the murders of the victims. B. Law enforcement began investigating the links between the crime scene and Odinism, Norse paganism within 3 days of the murders. C. That law enforcement began investigating Brad Holder and Patrick Westfall as suspects within 3 days of the murders. D. That at least 3 law enforcement officers continued to investigate into the Odinist Norse paganist ties to the murders, and particularly ties between Brad Holder, Patrick Westfall.
You can. You're not allowed to file an original action. That's illegal.
It's illegal. Get the fuck out. Or no, what did he say? Shut the fuck up.
Everybody shut the fuck up in this courtroom.
Did he say? He didn't say fuck. Angela, he didn't say fuck.
I have no idea who Sarah is.
Yeah, right. Yeah, right, liar. Okay. I am not going to look at you. You're going to distract me. At least 3 law enforcement officers continue to investigate into the Odinist Norse paganist ties to the murders, and particularly ties between Brad Holder, Patrick Westfall, and certain men in Rushville, Indiana, to the murders. E. That Richard Allen had no connection to Odinism, Norse paganism, and therefore could not have left signatures of Norse paganism at the crime scene. (11) In spite of the prosecutor knowing defendant Allen's third-party defense on September 18th, 2023, the prosecution waited over 7 months before filing its motion in limine on April 29th, 2024. My gosh, it's almost like we were just talking about that. It's almost like the judge was like, hey, by the way, you're running out of time. If you want to, you might want to do it. The prosecution's motion was filed 15 days from the May 14th trial setting. On April 29th, 2024, the prosecution filed its motion in limine requesting in paragraphs 7A and 7B that the court prevent the defense from presenting evidence that explains the defense's belief of what the crime scene shows, i.e., that certain signatures the killers left at the crime scene revealed that a ritualistic killing occurred at the hand of Norse paganists/Odinists. Because Richard Allen has no ties to Norse paganism nor Odinism, the evidence the state of Indiana saw excluded would prevent Richard Allen from arguing that Richard Allen did not commit the murders, as he knows nothing about Norse paganism, and therefore would have had no motive or knowledge to leave signatures of Norse paganism behind. No shit. I'm sorry. I'm trying not to cuss so much. On August 1st, 2024, the defense presented evidence through expert witness Dawn Perlmutter, DP, that the crime scene was a textbook ritualistic killing. God.
You can't file an original action. Look what I can do.
This opinion was offered from an expert who literally wrote the book on analyzing a crime scene for ritualistic murder, and also has taught FBI and other law enforcement agencies all over the country what a ritualistic crime scene looks like. Furthermore, Dr. Perlmutter has almost exclusively worked for law enforcement and prosecution, not the defense. And I know that because Courtney Yellowjacket told me, because she was listening very attentively in the courtroom. She's like, I don't even go here. I don't even work for y'all normally. Like, these MFers are so crazy that I switched sides for the time being. She didn't say that. I'm gonna stop ad-libbing. Am I on page 9? Yes. Okay. The jury would be able to assess the weight to give Dr. Perlmutter's assessment of the crime scene. 12. Furthermore, in its April 29th motion, in limine, paragraphs 7C, 7D, 7E, 7F, 7G, and 7H, the prosecution requested the court to prevent the defense from presenting evidence that tied alternative suspects involved in Norse paganism and Odinism to the murders, including evidence of the investigative efforts of the 3 law enforcement officers who believed that the evidence credibly pointed the finger at certain third-party suspects, and also social media posts that provide a nexus between certain third-party suspects in the murders. The Noiv. Oh God, wait. This state does not want David Schilling spilling his beans either. Sure don't. I love that you said spilling his beans. Okay. Debbie asks, who's Dave Schilling? Dave Schilling is an individual who authored a book on Odinism in corrections settings specifically, right? And I'm sure that Fiend in the chat and other people in the chat can probably give a more detailed answer than that, but he is somebody that the state has, or I guess is or was using as a witness, or will be using as a witness. Okay. Proceeding. 13. Yeah, 13. Furthermore, In its April 29th, 2024 motion in limine, paragraph 7I and J, the prosecution requested the court to prevent the defense from presenting evidence that third-party suspects Kagan Klein and Tony Klein committed the murders, even though, here we go, Old Hart's probably blowing his load right now. I'm sorry. That's so crass, but fuck them. Third-party suspects Kagan Klein and Tony Klein committed the murders, even though credible evidence existed that A. Kagan Klein had arranged to meet one of the victims on the day of the murders. B. Kagan Klein implicated his dad, Tony Klein, as being involved in the murders. C. Law enforcement tried to tie Richard Allen to Tony Klein. C. Law enforcement tried to tie Richard Allen to Tony Klein and arguably only interrogated Richard Allen because of law enforcement's initial belief that Tony Klein and Richard Allen knew each other and committed the crimes together. I didn't know that, court. I didn't remember Vito saying that. Yeah, no. I mean, it didn't register, I guess. Sorry. Okay, moving on. D. Law enforcement officials discovered a cache of child pornography on Kagan Klein's personal cell phone during the course of their investigation. And E. Law enforcement... Law enforcement officials actually transported Kagan Klein to an area near the crime scene to corroborate his version of what he and his father Tony did near the crime scene on the day in question. Yes, they sure did. Yeah, see, I don't think I knew this. Did I? Was I eating steak when you said that, Courtney? I might have been out eating steak. Because I don't remember that. That's very interesting. There are things that we are going to keep learning, I imagine. 14. Furthermore, in its April 29, 2024, motion in limine, paragraph 7K. The prosecution requested the court to prevent the defense from presenting evidence of third-party suspect Ronnie Logan, even though credible evidence existed that A, the bodies were found on Ron Logan's property. Always. It's amazing I had time to do this live tonight, you know, because of how frequently I'm engaging in that, you know, extracurricular activity. Okay, Ron Logan, even though credible evidence existed that A, the bodies were found on Ron Logan's property, B, an FBI-authored probable cause affidavit stated that Ron Logan placed a phone call on or around his property around 2:09 using cell tower data. We didn't know that specific. Or did we? Two. Two. Ron Logan provided false information about his activities during the crimes, during the time the crimes were committed, and employed others to assist in deceiving law enforcement, and furthermore plotted an alibi for a crime that had not yet been discovered. Sure fucking did. 3. A court found that said probable cause affidavit provided probable cause evidence of the murders would be found on Logan's property, and that was signed by a judge, which we can't say in this case, can we? 15. Furthermore, in its April 29th, 2024 motion in limine, paragraph 8. Yeah, this part pissed me off in that order. The prosecution requested the court to prevent the defense from presenting evidence from law enforcement officer Todd Click, who investigated the Norse paganist Odinist ties to the murders, as well as the ties of certain third-party suspects to the crimes, primarily those identified in paragraph 7A through H of the state's motion in limine. Click's testimony would provide evidence that connects those third-party suspects to the crimes, as would the testimony of... So sorry, I always do that and then you can't see the document. Testimony of law enforcement Kevin Murphy, who also investigated said connections alongside Click, including testimony that Elvis Fields posed the question to him if Elvis's, spit would be found on one of the girls, but he could explain it away. Would he, Elvis, be in trouble? Who knows? Furthermore, Murphy would be able to tie Elvis Fields from Rushville, Indiana to Brad Holder of Logansport, Indiana, and that Brad Holder was an active Odinist whose son, Logan Holder, dated one of the victims, who also has changed his story multiple times about whether he'd ever met the victim, and whose social media posts included evidence that tied Holder to the crime scene. To say that, I'm sorry, Brad Holder's the father of Abigail Williams' boyfriend. This judge is something. Okay. Furthermore, in its April 29th, 2024 motion in limine, paragraph 9, the prosecution requested the court to prevent the defense from presenting evidence of geofencing, even though that geofencing evidence provided evidence that other third-party suspects were in the area of the crime scene at the time the prosecution is claiming that the crimes were committed. You can't have it both ways. You can't say this is exactly when the crimes occurred, but then you exclude geofence that literally puts people there. Fucking A. 17. After the May 13th, 2024 trial date was continued, the court held the hearing for said motion in limine on August 1st, 2024, and likely because of the voluminous amount of evidence it received and reviewed, the court was unable to rule on the state's motion in limine until September 4th, 2024, which was 40 days before the scheduled October 14th trial date. That was very gracious of them to give judgical justification for being a lazy judge. Read it again. Which part? 17? Right. Oh, okay. Sorry. 18. Included in the court's ruling was the court's belief that the admission of the evidence would confuse the jury. The defense respectfully rejects that premise. Respectfully, Your Honor? Get the fuck out. Respectfully, Nick? Evidence that the court excluded from the jury would actually provide the jury an understanding and explanation of why the crime scene appeared the way it appeared. In fact, the defense would argue that by keeping the evidence of Norse paganism from the jury, the jury, would be confused as to why the crime scene appeared the way it appeared. Additionally, the inclusion of evidence of third-party suspects as being connected to the murders is not confusing, but rather easy to understand. Sorry. Additionally, the inclusion of evidence of third-party suspects as being connected to the murders is not confusing, but rather easy to understand. And that it's up to the jury to either accept or reject the defense's contentions that the evidence connects Norse paganism and Odinism and third-party suspects to the crime. 19. Essentially, with its September 4th, 2024 order, therefore 40 days before the trial is scheduled to begin, Richard Allen's defense was completely gutted. Period. 20. Certainly, between the Franks notices that have been filed and were made part of the record and the exhibits that were attached to those filings, as well as the evidence and testimony this court received during the July 30th to August 1st hearings, the Court of Appeals would have more than enough record to review to either support or negate this court's order, as well as the other one. 21. The issues to be presented to the Court of Appeals for Interlocutory Appeal concerning paragraphs 7, 8, and 9 of the State of Indiana's April 29, 2024 motion in limine would all involve whether the trial court was correct in granting the state's motion in limine, thereby denying the defense the ability to present evidence, A, concerning its interpretation of the crime scene and how said interpretation excludes Richard Allen as a suspect, B, concerning whether a nexus existed between certain third-party suspects and the crimes, and C, whether evidence presented warranted the court from excluding geofence evidence. On August 28, 2024, order denying defendant Allen's request to suppress incriminating statements violates Allen's state and federal constitutional rights. Sure fucking does. 22. On November 3rd, 2022. Diener! Where's Handy Mandy? Where's Mandy Handy Bay? Where's my bae? Where's my girlfriend? Where's my deposed Diener, my hourly deposed Diener tweet that literally gets me through the day? On November 3rd, 2022, Judge Benjamin Diener issued a safekeeping order, which resulted in defendant Allen's immediate transfer to a maximum security IDOC confinement facility, wherein he was detained in solitary confinement for a period of nearly 13 months. Fuck's sake. I want to read this after. Defendant Allen was not afforded a due process hearing regarding his detention until June of 2023, nearly 8 months after he was locked away in solitary confinement. So just taking a little bracket pause here for a second. The defense requested an emergency due process hearing on, there she is, April 5th, 2023. An emergency hearing because their client was being tortured and was in a psychological and physical crisis. Amazing. That sounds also amazing. This judge waited and scheduled that emergency due process hearing for 2 months later. And we all know what happened in the span of those 60 days between their request and her scheduling that hearing. What happened was they probably got 60 or 59 more confessions out of the guy, so that worked out really well for them. Throughout the course of defendant Allen's detention, the state of Indiana began offering up discovery in the form of incriminating statements made by defendant Allen to prison guards, inmate companions, the warden, defendant Allen's treating psychologist, and his family members. What? Who yelled at you, Gina? Not on my watch. Gully did emergency. She did emergency. She sure did. Oh my god, Pop Tardy's here. And Christine Beck is here. Hi, Christine Beck. That's a lot. Okay. 24. Defendant Allen then moved to suppress the admissibility of said statements on the basis that said statements were involuntarily made and thus obtained in violation of defendant's 5th, 6th, and 14th Amendment rights under the Constitution. Defendant Allen also asserted that his rights under the Indiana Constitution were violated. Right. It's insane that the lazy judge motion got denied because the defense defended themselves against the motion in limine. So the reason that the lazy judge motion, which should have absolutely been, granted, they should have been given, allowed to enjoy their, defendant Allen should have been allowed to enjoy his right to have timely rulings in his case. And that motion got denied because the defense had the audacity to respond to the state's stupid bullshit motion in limine. So they, canceled out their right. They're like, well, you didn't, yeah, anyway. We've talked about that before. Oh, no. Just did something. Lord. I lost my document. Oh, I found it. All right. On August 28th, 2024, this honorable court, I bet Auger wrote this, maybe not, issued the amended order or judgment of the court denying defendant Allen's request for suppression and holding in totality, that the statements given by Allen, by the defendant to the various individuals were not coerced, were voluntary, and were not the result of interrogation by the state or its actors, nor the product of his confinement. 26. With regard to the August 28th amended order, the issues to be addressed were as follows. Oh, amended order. So I don't know if that's a thing or not, but remember we were trying to figure out what was amended in that order? I don't know if this gives any insight, or maybe not. Maybe I'm just seeing things that aren't there. With regard to the August 28th amended order, the issues to be addressed are as follows. A. Was Richard Allen denied his right to due process under both the state and federal constitutions when he was detained in solitary confinement without having been afforded a timely hearing on the state's motion for safekeeping order? B. Did the effects of defendant Allen's extended solitary confinement render statements made by him to the prison guards, inmate companions, the warden, defendant Allen's treating psychologist, and defendant's family members involuntary and therefore inadmissible at trial? Thank you. Okay. I thought so. Maybe you can explain that in a little bit. or another day when you can, because I don't quite, I'm curious about what this is saying. Okay, C, were the statements Hi, Truth Seeker. If Fiend wants to come on later, well, I don't know how to explain it, Gina, but if DB wants to explain it, he can, or maybe Michael can too when he comes on. But so remember, she issued an order and then an amended order, and we were like, huh? Oh, it's new. Sorry, I'm like in the zone. Remember that time when the defense filed that really long motion? I started reading it, and then I skipped all the new information about how all the third-party suspects were connected, and Fiend, I could like feel the heat coming out of his ears from all the way across several states. I'm not gonna do that again. Let me finish reading. Okay. Forget what I said, Gina. I did a boo-boo. DB made a joke, and I didn't get it. This is also a good point. Diener, I guess, signed the PCA, although we still can't find his signature on the actual PCA. But he also helped write it. Very true. He also wrote the safekeeping order. Kind of like the way that Judge Gull, like, pretty much wrote the state's motion in limine when she was like, hey, here's all the things that you probably could do. You didn't miss anything, Gina. I misled you. C, were the statements allegedly given by defendant Allen to his treating psychologist privileged? You think? I get really triggered when we talk about Walla. The August 28th, 2024 order involves a substantial question of law that could be resolved on appeal and lead to a more orderly disposition of the case. Defendant Allen's incriminating statements stemmed from a most unique detention circumstance. Allen nor his counsel were given no choice in the matter. So that, for one, he didn't have counsel when safekeeping was ordered. He was not even granted a hearing. I bet they didn't even tell him where they were taking him. They probably just put him in a van and were like, okay, kiss your chair and table and mattress and toilet that's more than 18 inches from where you rest your head at night goodbye for 2 years. Like, he had no idea what he was in for because they didn't tell him anything. And they didn't tell his attorneys because he didn't fucking have any. He didn't have attorneys until he was in DOC already for 2 fucking weeks. Thank you. They kidnapped that man. And if he, God forbid, thank goodness he didn't, but if he died in DOC, I would charge them with felony murder myself. Because fuck them. They kidnapped that man. Defendant Allen's incriminating statements stemmed from a most unique detention circumstance. Allen nor his counsel were given no choice in the matter. The issue of first impression here is whether or not defendant Allen's due process rights were violated, i.e., does the safekeeping statute require the court to conduct a hearing? This is like Christmas to me right now. I'm going to read it. Does the safekeeping statute require the court to conduct a hearing to address the propriety of defendant's pretrial detention circumstance? Defendant Allen is unaware of any rulings in this state addressing this very issue. Defendant Allen is unaware of any rulings in the state addressing this issue. If the Court of Appeals were to find in defendant Allen's favor the admissibility of statements and other evidence stemming from defendant Allen's wrongful detention would be inadmissible. I had to stand up for this. I'm going to read that again to y'all. If the Court of Appeals were to find in defendant Allen's favor the admissibility of statements and other evidence stemming from defendant Allen's wrongful detention would be inadmissible. That means because he was there against his unconstitutionally. Hi, Travis. You can come on later if you want. If the Court of Appeals found that his due process rights were violated through safekeeping, every fucking thing that came out of his mouth in DOC would be inadmissible, period. Because it would be no different than kicking the front door down of a veteran playing paintball, seizing all his shit with no probable cause, and then trying to enter all that shit into evidence in a case against him. The judge would be like, no fucking way. You don't get to do that. That's not how we operate here. It's no different. You do not get to violate a person's rights and then enjoy the benefit of evidence seized as a result of violating their rights. Period. So there is very good reason. Yes, 100%. And this has never, they literally just said, this has literally never happened in the state of Indiana because Carroll County is Whoville. It's awful. They do things that they don't do other places and they get away with it. Until fucking now, because it's ridiculous. You know how many people they've probably done this to? How many people are sitting in DOC just because Carroll County are a bunch of weirdo ass clowns who think the rules apply to everybody but them? I need to finish this though. Can I read this one again? I'm going to read it again really fast. The August 28th order involves a substantial question of law that could be resolved on appeal and lead to a more orderly disposition of the case. Defendant Allen's incriminating statements stemmed from a most unique detention circumstance. Allen nor his counsel were given no choice in the matter of safekeeping, the matter of being in DOC custody. The issue of first impression here is whether or not defendant Allen's due process rights were violated, i.e., does the safekeeping statute, Indiana Code, require the court to conduct a hearing to address the propriety of defendant's pretrial detention circumstances? Okay, good point. Defendant Allen is unaware of any rulings in this state addressing this very issue. If the Court of Appeals were to find in defendant Allen's favor, the admissibility of statements and other evidence stemming from his wrongful detention would be inadmissible. So now I hope it's making sense as to why they're like, we don't want to fucking talk about safekeeping. Oh, safekeeping? No. Keep it moving. Move right along. All of their evidence was obtained through safekeeping. They cheated. You can't do that here. 27. The remedy of an appeal is otherwise inadequate for all the reasons stated herein. Did I turn the page now? Because of the pending trial date, the defense would further request that this court issues its ruling on this motion as expeditiously as possible. Keep in mind, and Michael and or Travis or anyone else who wants to, who knows more than I do, can explain a little bit better probably the process of interlocutory appeal, but this motion that they have filed is in fact going to the court. It's going to Judge Gull. This is for her. She reads it and rules on it. And that, you know, that's problematic for a lot of reasons, but, you know, there's remedies to deal with whatever bullshit she pulls, but they are asking the court to issue a ruling on this motion expeditiously because they have a trial coming up in a month. 29. The state of Indiana has been contacted and objects to the request and waives the 15 days to respond, as they've indicated that they will promptly file their objection. You know they will. Nick's like, what is an interlocutory? Just kidding. 30. Based upon the pending trial date, the defense would respectfully request this court to rule on this matter as expeditiously as it can, and believes the prosecution would also benefit from an expeditious ruling. Would love that. I'll put the link out for you, Travis. This motion is not made to unnecessarily delay the trial, but out of a sincere belief that this court's ruling is erroneous, and will result in an unnecessary second trial should Richard Allen be found guilty. Wherefore, Richard Allen, by and through counsel, would request this court to certify the issues presented herein for interlocutory appeal to be heard by the Indiana Court of Appeals. Please up the volume. Do you mean that literally? Or just like... respectfully submitted. Andrew Baldwin, Bradley Rosie, Jennifer Auger. There you have it, folks. Andrew Baldwin, the criminal defense team, Baldwin, Perry, and Wiley. That was a really good. What did we think about this? Let me put the link. I also tweeted the actual document if anyone wants to like read the actual document and just have it, because you should. But what does everybody think? Audio files. Is there something wrong with my audio again? Please tell me, because I have no way of knowing. Like last live I didn't know because everyone was actually being really nice to me and didn't tell me that my mic was glitching the whole time. And I don't know how y'all didn't roast me. It was awful. So please tell me if that starts to happen again. No problem with audio here. Okay. This is the link to the actual document. Travis or Michael, yes. Speak of the, and he shall appear, except in this case. Michael, welcome, my friend. I'm so happy that you're here.
Oh, sorry about that.
How are you?
Ah, a little disappointed in the motion.
I knew you were going to say that, and I expect nothing else, and I wouldn't want to change anything about you, because I was just about to say how much I loved it. Tell me, please, about the motion, though, because I want to learn.
Well, they've got a good beef about the third-party evidence.
Mm-hmm.
There's an echo going on. Oh, am I still on YouTube? Is that what's caught?
If you're hearing it, yeah, if you're hearing, well, I don't know, unless you're hearing it, if other people are hearing it on my end, but it could be like if you have it open in another tab or something. Sometimes I do that. No?
Don't have it open anything else. Anyway, oh, Travis is here. They go straight for the Sixth Amendment right to prevent. Let's deal with the third-party stuff first. They go straight for the Sixth Amendment right to present a defense. The problem with that is it's the due process 14th Amendment right to present a defense, not a Sixth Amendment right. That's Chambers v. Mississippi and Holmes v. South Carolina and a few other cases, including some from the Seventh Circuit. And generally the structure of the thing is just wrong. Gull's order actually, so the case that McClelland relied on in his motion in limine on the third party stuff was Pelley. And Pelley was all about hearsay supporting a third party defense. And all of Brad and Andy's evidence is not hearsay, as far as I can tell. Perlmutter's testimony isn't hearsay. The confessions of other people aren't hearsay. The direct testimony of Click and Murphy aren't hearsay. Horan's testimony would not be hearsay. And this, I don't know of a single case with all this admissible evidence pointing to other people that you haven't been able to get the evidence in under the rules. Now, we'll get to 403 in a minute. Anyway, she finds a nexus with admissible evidence. I mean, that's only if you buy the state's timeline. And in essence, what she's doing is deciding jury questions for Nick McClelland. and she shouldn't be doing that.
No.
And Travis is free to disagree with me and call me out. So then we get on to 403. So 403 permits a judge to keep out relevant evidence if there's a danger of a list of things confused, but she only mentions, I think, confusing the issues and misleading the jury. Well, no. Now that'll be reviewed as for an abuse of discretion. That's a pretty nasty standard, but I'm telling you, it's an abuse of discretion in this case. It just is.
You mean by an abuse of discretion on behalf of the judge?
By everybody's favorite judge. And it's going to be an abuse of discretion because, yeah, I mean, it would confuse, has the potential to mislead the jury that Rick Allen is innocent.
We don't want to confuse the jury and make them, we don't want you implanting any thoughts about reasonable doubt.
No, the keeping out Haran's testimony, the third party guilt. Now, you could look, I don't know really what the Messer evidence is, and I really don't want to use names on it. So, we'll get in, you can get into individual witnesses, but writ large, Nick McClelland can put on at trial the BAU's conclusion that this was not a ritual sacrifice, this was an undoing. But that's a jury question. I mean, it's like this is, you've got a direct evidence from an expert that this was a ritual killing. Now, I don't happen to believe it was a ritual killing. I think it was dressed up afterwards to look like it, but I don't know. Libredo certainly seems to think it's a ritual killing, and there's an expert. So what do I know? But I just think it more likely that it was more like an undoing, that there was a murder for other reasons, and then some folks dressed it up a particular way for particular reasons. But that doesn't. But that's a jury question. I mean, it's just a plain old jury question.
Right.
End of story. And I don't think so. So yeah, I mean, everybody's favorite judge has to certify the question. As I have said before, I feed stuff into Brad and Andy, but get nothing out. And while you were reading, I sent them off an email saying, got to go amend that motion for an interlock, saying basically what I just said.
Well, good, Michael. Good. I'm glad that you do that.
I came in, Michael. Nice to see you both again, by the way, figuratively and literally. So I came in about the last 2 pages of Angela's reading of it. What are the issues that they raised in the interlocutory appeal?
I will pull it up again, Travis.
So the grant motions to eliminate motion to eliminate on third party evidence, suppression of statements. They're trying to. I just don't think the suppression issue was litigated in a way in the hearing that you're going to be able to get at this point meaningful appellate review. And I kind of think, yeah, there's this question about whether
I agree. So they didn't raise Sixth Amendment, 14th Amendment.
They did.
Oh,
yeah, right.
Well, but the Sixth Amendment right, they raised the Sixth Amendment right to present a defense. But my understanding, at least from Chambers v. Mississippi and Holmes v. South Carolina, is it's a 14th Amendment due process right, not a Sixth Amendment right. But
well, fortunately, Judge Gold doesn't know about any of those, so she won't know the difference.
Well, I'm sure. I'm sure she's lurking in the chat there. So
Travis, I'm gonna link the actual document in the chat here so you can like pull it up. But they go through yeah, that's
I look, their 14th Amendment claim, due process claim about the conditions of his confinement. I mean, I don't think they even mention. Do they even mention the word involuntary in the motion?
in the what, Michael?
In the motion for the interlock, do they even mention involuntariness? In other words, the confession was involuntary.
Let's see. Well, there's an easier way for me to do that, so please hold.
I mean, I think the point they're trying to make is that because of the conditions, it was coerced. And as I've said in a few places, of course, all coerced confessions are involuntary, but not all involuntary confessions are coerced.
Right. Well, so I would argue they were certainly involuntary, but I don't really care if they were coerced or not. I don't even think
I'm
that's
making a point about the argument there, so that they don't get to make an argument in the Court of Appeals they didn't make below. And I think what they're claiming here is, and they did claim this, I think, that the mere his conditions themselves rendered the confessions involuntary, not that he was out of his mind at the time in particular, but the whole shebang. I mean, I think at the hearings they should have gotten I've heard from some people on YouTube who claim to actually have information from people in prison who were, Rick's safekeepers, or some of them, not all of them, and about, questioning Rick. Now, I think that the only thing these folks could do would be sit there and listen, and not ask anything. I think I think for those folks that Brad and Andy needed to get into court if they knew who these people were.
the safekeepers.
Yeah, the safekeepers. They had to get people into court to testify that we had conversations about it. Maybe he started them, but asking.
Well, didn't I think that
They
was
can't
a
answer.
huge part of Walla's testimony that we will not get to see for probably that exact reason, because I think at one point they did raise the issue of safekeeping, and you and I, even Michael, and you remember when we were going through IPASS, I went through the Plus program I went pretty deep down that rabbit hole, and there's like no ambiguity about safe what are they called, companions cannot interact in any way with the person that they're watching. Like, they just can't, and it sounds like that was just ongoing. So I know that they brought that up at the hearing, but I don't know if it was presented in any, like, I don't know what exhibits they offered up or whatever.
Yeah, I don't recall from anybody's notes that there, was anything about the safekeepers, the companions actually in or not with Rick. And as I think notes, Brad was saying, there are various buckets, and that's right. And I think they're just trying to do a global suppression. And I think they've got to keep. I mean, there are different grounds for all of these confessions. I mean, the companions are one set of grounds. I mean, they may be overlapping, so that the confessions to the companions and to Rick's mother and to Kathy might all fall under the due process umbrella, but they have specific reasons they might be suppressed as well. I think anything he said to Walla is suppressible, for the lack of I mean, she's clearly a state actor. She's clearly talking to him. I don't know where HIPAA kicks in, but I don't think you even need to go to HIPAA. I mean, I think there has to be a Miranda waiver for him talking to her. I don't think that's been raised.
So sorry. At the
No, go
top
ahead.
here is the only use of involuntary I could find was at the top of this page here. One of the issues was, well, did the effects of defendant Allen's extended solitary confinement render statements made by him to prison guards, inmate companions, the warden, defendant Allen's treating psychologist, and his family members involuntary and therefore inadmissible at trial?
Yeah, and they don't tie that though to his mental illness, and they didn't really litigate mental illness substantially at the. I mean, they did actually with Walla. He was psychotic, and maybe look, you know, they can try.
Can I ask a probably like very obvious question, but so as I understand it, like law enforcement can't arrest someone and then interview or interrogate them at the police station while they're completely like in an altered state, right? If they're inebriated or if they're on, benzos or if they're just hammered, right? They have to wait until they're of sound, lucid mind generally for anything they say to be like.
I mean, if they're smart, they'll do that, but.
Right. So then in this instance,
but in any case, but the fact that you're slightly intoxicated isn't going to necessarily render your confession voluntary. It just gives the defense lawyer something to work with.
Right. So if you're receiving nightly doses of Haldol and involuntary injections of Haldol, which is, as we've talked about Haldol a lot in the past month, is a very strong, very intense antipsychotic medication for psychosis and schizophrenia, that it is what we use in treatment centers in my state because we don't use actual physical restraints in medical settings. We use chemical restraint, and the chemical restraint we use is Haldol. You get a Haldol injection in your butt, and it totally knocks you out. So how, in any universe, am I understanding that the incriminating statements he made, he was receiving Haldol all those months, and they're trying to have it both ways. They're drugging him with Haldol, and they're also saying that the things that he said while the state was involuntarily giving him Haldol, involuntarily, per that secret hearing, like those are all fine. Those are all he made in his, he meant exactly what he said, and he's totally able to make confessions while he's on Haldol. Like, I don't know if I asked that well, but do you understand, like, you know what I'm saying?
Yeah, and I just don't think that they lined up what statements go. I mean, you say I don't know what the dates he was getting Haldol on were, and when he was doing all the really unhappy things he was doing that we've all heard about. I don't know when statements were made in relation to that situation. So it's so my complaint about this is there are a ton of statements. 61 according to what is it, Harshman? And by the way, I mean we only have his word for it that there were things that only the perpetrator would know. I don't think at the hearings anything in particular came out. I think people are trying to say, oh, the box cutters. Well, I don't think it's been established that Abby and Libby were killed with a box cutter. Also seems really unlikely. But what I'm saying is, Brad absolutely said correctly, there are all these different buckets, but then within each bucket, there's timing. And, it's really, they're dealing with this giant thing, but and they're going to the Court of Appeals with the global claim that the mere, putting somebody in solitary for this long basically renders anything he said inadmissible, and that's fine. But there are subcategories that they really, I think, should have gone after,
Well,
particularly Walla.
yeah. Did they mention? Do you think that that will come up after? So they did request, or they subpoenaed Ducey Teacumed her, all of her employment records and everything last week. So I suspect they're not probably finished with Walla yet, right?
Possibly not. I guess they're going to probably want to see if she's been sort of disciplined for any way she's handled any of this. I mean, by all accounts, Wallow is an extremely sympathetic character at the hearing.
You think?
I mean, I've sort of heard that from multiple places, so I wasn't there, so let me put it this way: sympathetic in the sense that she seemed to really care about Rick. I'm not saying do a bunch of things she shouldn't have done, and as you and I know, not getting him to is it Newcastle or Miami? Is it Newcastle or Miami?
Newcastle and Wabash are.
Well, Wabash doesn't have much. I mean,
it doesn't.
The policy says Newcastle. It doesn't really.
Yes.
And if she recommended that and she was vetoed by Gallipo or somebody else, that's on them, not her. Doesn't mean she won't be disciplined for it. So I just don't know what they're doing with their employment records. And I really don't know what they're doing with Gallipo's employment record.
Travis, what do you think?
I'm still kind of going through the document, but Michael had brought up a long time ago in a chat presentation. He may not even have been on, he just may have been in the written chat. So did they raise that the original safekeeping ex-parte hearing, really, when Diener granted that at the request of the sheriff, apparently, did they raise that in the motion for certification that was a critical stage and therefore
it's not in this motion. It's not in this motion, and that's something to get the whole thing reversed after a trial if they need it. It's not really.
I feel like I just read it in this motion. Are we sure? I'm gonna find it because I read it twice because I stood up. Were you here when I stood up, Michael, out of my chair?
That's what I thought you were reading, but Michael had raised that, and I had confused sixth and fifth, and pointed out, no, it's sixth. And the case I'm familiar with is Rothgary versus Gillespie County because it's a Texas case. And,
absolutely.
And I agreed when Michael said, that's got to be a critical stage. Now, I'm not constitutional scholar like Michael is and don't follow all of these cases to the extent Michael does, but probably not much case law out there that says a a detention hearing like this to put you in a prison is a critical stage. But even if there isn't, I think there are many, many, many arguments that can be made that that's a critical stage because it had the real impact, not a hypothetical impact. It had the real impact of I think the language in Rothgary was anything that makes it difficult to defend your client. And it did because of physical distance, time, just would seem to me, especially in light of other areas of law and decisions by courts about mental competency, that uh, neither he or his counsel able to come in and argue against that would be a critical stage. Is there any law on that, Michael?
Rothgary's actually, I read it initially the way you did about being a critical stage, but that's not really what Rothgary's about. It's about the attachment of the right to counsel. And so where your bond or incarceration status is being determined, that at least is where the right to counsel attaches, whether you've been charged or not, I think. I don't think it's actually sort of reversing. Well, I'll have to go read Rothgary again. No, I'm with you. I mean, I think it's absolutely a critical stage. I don't know of any particular cases on this in this context where you're getting sent off to prison. And I think the statute actually calls for a hearing. And, in this case, you've got the sheriff filing a motion. The sheriff doesn't have any standing. And the judge just says, off you go. Now, I would say that there's some cases might say that would be subject to harmless error analysis, but I don't think you could say it would be harmless in this case. So I'm kind of with you, and I think it's not something to raise now. I mean, look, if you raised it now, what would happen? It would you just reset everything to zero, and there's kind of, it's not like Rick wouldn't get tried. It's not like it would all be over. I think you raised that as one of the issues in the direct appeal.
So can y'all hear me?
I can hear you beautifully.
So everyone's going to ask, I can't see the chat since I came on because I'm on my phone, but everyone's going to ask, Michael, so what if she denies the certification?
If she denies the certification, my guess is that they'll try an original action. That she is so wrong, and an appeal is absolutely, for the reasons set out in the motion, absolutely inadequate from all kinds of people's perspectives, from the perspective of Carroll County, it is so wrong. At least on the third-party guilt stuff and Perlmutter, and it is just so wrong that the Supreme Court ought to take it. And normally, you don't do original actions from sort of normal evidentiary / discretionary rulings. But, the Supreme Court, Indiana Supreme Court, opened that up, an original action too, by using all this discretion language, which they shouldn't have. And so they opened the door for that. Look, the situation we're in can squarely be laid. We would not be here but for the Indiana Supreme Court. And they left everybody's favorite judge on the case while putting Brad and Andy back, and that has just set all this up.
So stupid. It was a very silly thing to do, I feel like.
Well, I remember hearing Kara's reaction to the order granting the second original action, and because the language in it was just so bizarre. It seemed to pre-rule, prejudge bias. It seemed to encourage a contempt hearing. It seemed to seemed to do a lot of things that weren't in line with what Justice Rush said from one of the very first questions, which of Rick's counsel on appeal did such a great job in the oral argument. One of the first comments she made was she wanted to get the case back on track, and then you had this opinion order come out that did everything but get it on track. It seemed to me, but
Yep. I mean, you have it, for all the sort of factual wonderment in this case, y'all have seen in this case something you will probably never see again in your lifetimes, and that is a criminal trial of two people inside the criminal case of somebody else.
um, someone's asked a question, so explain that more, Michael, for people who are listening.
The contempt hearing, the so-called contempt hearing was a criminal trial. And it was a criminal trial of Brad and Andy inside Rick Allen's criminal case.
Right.
And that just, that doesn't happen.
Yeah, and one of the criminal defense attorneys, that does public defender work in that area, he's been on with Bob and Ali Mata a couple of times, like a younger guy, which he's probably in his 40s, but look, late
Shay?
30s maybe.
Shay Hughes?
What's his name?
Are you thinking of Shay Hughes? He's an Indiana public.
Yeah, that's it. Yeah. And Shay had mentioned in a post that, the arguments are great about the framework provides it should have a separate cause number, it should be a separate proceeding. But he said he goes, I hope they're aware that in that county, I don't think he said county, in that area, he may have said county, that it was standard practice in the rare occasions where there was a contempt hearing that it was held within the original criminal case, which just seemed utterly bizarre to me. But
I have seen a criminal contempt, indirect criminal contempt trial of a defendant in that defendant's underlying criminal case, but I have never seen an indirect contempt trial of other people inside somebody's criminal case.
Haven't either. Mike, that's what Michael's explaining for everybody listening, that never seen before, probably never see again, where there was actual criminal trial of somebody else within somebody else's criminal trial, that being Rosie and Baldwin in Richard Allen's criminal case. Just have never seen that. But according to Shea, and I'm pretty sure he's referring to someone other than the criminal defendant or a party to the case that they don't get a separate cause number. They just do it within. But as a practical matter, you really don't. It doesn't really go to the extent where there's actually a evidentiary hearing on contempt. Usually, because the thing gets sorted out, the person says they're sorry, they won't do it again, and it moves on. And it really never even has to go that far, but she just was really insistent on doing that. And then that's where we got the two famous footnotes that I like so much. But
Well,
so
and Brad and Andy should have filed an original action then, but they had a trial coming in May, and they made a decision not to do that.
yeah. And then who knew what was going to happen going into it. But Angela, can you remind us what something did come up last week or maybe week before last about things they wanted in reference to Dr. Walla? What was that? And
Yes. So the defense filed a couple subpoena deuces tecums, right? Deuces
yeah,
tecums. They submitted to the Indiana Department of Correction for Walla's employment record, and I'll read it verbatim in a second, but her employment records, any disciplinary actions, any documented anything, and then they also submitted one to the Attorney General's office for the same thing. And I think they also submitted one to Centurion, who is the company that contracts with DOC, who's technically her, employer. And they requested.
and then the state moved to quash some or all of those. Is that right? And she ruled on some or all of those.
So, I don't know if they. I'm going to tell you for sure in a second. I know that they did. Go ahead, Michael.
The state moved to quash
the other doctor.
Succeeded at the subpoena of the doctor over in,
Yeah,
I don't know,
it was another doctor.
County or someplace.
But that was quashed based on scheduling and unreasonableness and but I don't know if I don't believe that they quashed the request for Walla's stuff, right? Unless I missed it.
Don't think so.
And then
don't think there's been a motion to do it.
I don't think so either, Michael. And then I know just before they filed the interlocutory, they filed all of the same requests, but for Borden Gallup who. So
right, that's
to
right.
DOC and AG.
So the only reason we knew about it is because you don't have to file subpoena ducis tecums in the public record. I presume the attorneys can send those out on their own and sign those subpoenas. The reason we knew about it is they wanted to shorten the response from 30 days to 15 days because they had certain deadlines they had to meet, needed the documents sooner. And she granted the shortening time, right? Or do we know?
I believe
don't think we know, and it's not, but it's, so with third-party subpoenas, they have to give the opposing party 15 days notice before issuing them. And what they asked for was, I think, shortened to 5 days. In other words, McClelland has 5 days to move to quash if he wants to.
Yeah, and I read some of those that if you're subpoenaing a state agency, you had to give that 15-day notice, and that part of the motion shortening time, reducing the time, was also it was more for the AG being able to respond or not. But he also indicated in there that they had a conference, which a lot of courts require, saying you tried to work it out and that they were unable to work it out. And I thought in one of those, he referenced the AG's office, not who would be filing the motion to quash, since it's the Indiana Bureau of Prisons or whatever they call it. But and so it got filed in a court docket, but we might not necessarily know what the judge did on that, Michael.
Oh, I think you're muted, Michael.
Yeah, no idea.
Okay. Well, if it's not, can you explain a little bit more what you think? Because when you talked about the when you talked about, Michael, in the past, that the safekeeping terminations were a critical stage and didn't have counsel, and if they were considered to be a critical stage, then anything obtained while it was away and under the safekeeping order could be argued to be fruit of the poisonous tree. So I was thinking now is the time to strike, but you're saying that that's something that would be better for appeal post-conviction, and I kind of wanted to flesh that out a little bit or make sure I understood that and why that would be. Because I'm thinking, yeah, it's a reset, but if those confessions are tainted because, and I like to call them admissions rather than confessions, because they're just not confessions in the normal sense, that you're being questioned, you're being led in different directions, because the last time that happened was Holman interviewing him, where I thought Rick Allen did a great job of basically telling Holman to F off. And
I can't wait. Let me interrupt you there for just a second. I mean, when it comes to putting the confessions in, Nick does that, and boy, oh boy, if I'm Brad and Andy, I don't know what they're going to do, but I sure would want the jury to see, and you wouldn't be offering it for the truth or anything else, but I would want the jury to see the difference between Rick Allen talking to Holman and Rick Allen on video after he's been in SEG.
Hell yes, Michael. Totally agree.
Yeah, 100% on that. In fact, you and I, Michael, both at various times questioned why that was even the subject of a suppression, and then it was abandoned first day of the hearings, which did make a lot of sense. But
But
I
to go to
suppose,
your
yeah, go ahead.
to go to your question, no, if they could reasonably use the absence, so if they could use his ending up, I mean, I don't. So it's kind of it's it's after Miranda, I guess. Yeah, I mean, if you can say that the confessions should be suppressed as a result of his being put in the DOC without, and that process happened without a lawyer, and you can suppress the confessions because of that globally, then yeah, maybe. But the problem you're going to have with that, and maybe not, is, attenuation.
Yeah, but it was your idea. I thought it was brilliant at the time.
Yeah, I
Maybe
don't.
maybe you had a glass of wine when you.
Yeah, I don't. I actually don't. I don't. It's nice. It's nice to have things brought back to me as my ideas. I actually don't remember having that idea, but
Yeah,
I
you
think my
did, and
idea.
I thought it's ultra brilliant. The only reason I remember it is I flipped fifth and sixth, but again, I don't know all of the nuances of things like you. I always thought that the sixth, if it was a state court action, um, was through the 14th because of incorporation. But
Well, yeah, of course, it's always that because it's but it's through the 14th. But people just talk about the 14th Amendment drops out in most pleadings. I mean, maybe I'll include them for the sake of completeness and a point heading in the Seventh Circuit. But at the trial level, everybody knows it's the incorporation of the 14th Amendment. So
right, you were discussing it earlier, and I just wanted to be sure I was clear on that. But
no, no. I'm making a different point about that. We're not talking about incorporation here. Chambers and Holmes, the right to present a defense is related to the right to a fair trial. It has nothing to do with the right to counsel, the right to confront witnesses,
right,
the right to a jury. It's not a Sixth Amendment thing at all.
right, and it sounds to me like um, your initial impression is they may have conflated those two, and they need to clean that up a little.
Yeah, I
Or
mean, you're trying to get the judge to certify a question for the Court of Appeals. I mean, it's certifying order, but in asking, because now they're asking for this under the Sixth Amendment, and like if they go, like if you're asking under the Sixth Amendment, well, you don't have a right to present a defense under the Sixth Amendment, so no, we're not taking the question.
right, so just for everybody's edification, when you certify something, anything, you're you have a case in federal court, and it deals with state law, and federal court said, well, there's no law on it in this state, what to do. Certify it to the Supreme Court of the state judge. There's a provision that allows you to do that in the state appellate procedure. Let's certify a question, and then that's where the real lawyering comes in, is going back and forth and getting the precise question. Because what's the first rule in appellate law, Michael? He who frames the issue, what?
Well, I think the first rule is if you don't raise it below, you lose above.
Right, but
And
once you get it, the person that frames the issue, and you'll hear this over and over and over again, even the U.S. Supreme Court, when the court says the issue in this case is, and you look, whose issue is that closest to in the briefs? The prevailing party is usually the one where the court states the issue, that closely matches the party that framed it that way.
let me interrupt you for a second, Travis. The Indiana Court of Appeals is famous for saying things like the appellant raises three issues, which we restate as, and it's like, don't restate my issues.
The point being, it's very, very important to be precise about the issue. The whole thing is inextricably intertwined. It's chess, and you're stating the issue where the opening moves in a chess match, with the end game It's a poor analogy, but the way you frame issues are critically important. And when a court says something, we restate the issues as thus. It usually means they're trying to get around deciding which should be decided, right, Michael?
Well, yeah, I mean, at a higher level, but I mean, this is really checkers. This is checkers at this point. It's like, no, you you have to state the provision, the constitutional provision, the correct constitutional provision under which you're raising your
Right.
claim.
Right.
This is
Well,
this is
yeah,
not that.
yeah. But so let's dig into that just one layer deeper. So this is asking to certify the question. So she went ahead and granted the motion to certify it. It would, she would just,
So she's only certifying. Technically, let me interrupt you again. She's technically they're just asking to certify the order.
okay.
In other words, granting McClelland's motions in limine about the third party defense. Let's leave out the suppression.
Okay, so they would
So
be free to argue and submit what issues they think derive from the order.
probably, but like the reasons to grant the interlock, it's like the legal reason that the order is wrong, they say, is the Sixth Amendment right to present the defense.
Right.
And I mean, it's really not complicated. It is not the Sixth Amendment right to present a defense. It's the 14th Amendment due process right to present a defense. And I can tell you that, if this were to end up in Fed court, they'd say that, the claim wasn't either fairly presented or wasn't.
What
I
wasn't
mean,
raised below. That's
well, it
for sure what would, yeah,
wasn't raised in the state court.
yeah, that's for sure what would happen in the Fifth Circuit Federal Court of Appeals. No, there's no question. They're not very sympathetic
But
to
I mean,
that
this is
at all.
and I understand the mistake. I understand the mistake. And I understand these are trial lawyers and they're busy and they're in a hurry and all the rest. But I mean, I got to say, before Angela was going on at 6, I said, am I crazy? And I went and looked up Chambers, and no, it's the due process right to a fair trial.
Angela, did you go ahead? Sorry, go ahead.
And they can amend the interlock request without much effort. But I was making a bigger. I mean, I think earlier I was making a more important point, other than the mistake, that as reasons to grant the interlock is that Gull has actually violated the evidence rules in keeping this stuff out. In other words, you don't want to go for the right to present a defense until you want to back that up. So, I mean, what Chambers says is that, and the case that's following it, is that, the state's evidence rules aren't the end all and be all of, or the be all and end all of things. If you have reliable evidence that under the state, and there's a great example from Indiana in the Seventh Circuit. Case name is Cooks. It was a capital case, and there was a video of a girl who there was a video interview with a girl, and the girl could remember nothing about it. She couldn't remember the interview. She couldn't authenticate it. But as then Chief Judge Wood asked the Deputy Attorney General at the oral argument, so if this girl is right, you want to execute an innocent person, because this girl's testimony would have completely exonerated the guy. And it was a video. I mean, pretty reliable. but it was not admissible under the evidence rules. But you want to do that as a last gasp. You want to say all this stuff is admissible under the evidence rules, and that it is an abuse of discretion to keep it out under 403.
Right.
I mean, they have all this admissible evidence, and there is, and the other thing is that Gall's granting of McClelland's motions in limine assumes things about the state's case are true, and so is just
Yes.
it's she's deciding jury questions without a trial.
Yeah, she's also deciding. Yeah, and we said that when she issued the order saying that Brad Holder was cleared before, like, she's literally making decisions that should be made by nobody but the jury constantly.
Well, look, it might be a closer question if there was sort of uncontroverted evidence that the girls were killed between 3 and 4:30, but that evidence is by no means uncontroverted. And I don't know what the time of death evidence is. It's a very interesting thing. Apparently, there are two versions of when the famous pancake breakfast happened. Well, guess what? I don't know what the stomach contents evidence would be about the time of death, but boy, if there are two different versions of the pancake breakfast, then there could be really two different two different timelines there. No, I mean, Gull is, look, I just don't know how a judge, after having an expert say this is a ritual killing, and you have all these statements against interest by various people whom I will not name, plus law enforcement saying, yeah, we were looking at this. I've just never, I mean, Travis has more experience than I at trials for sure, but how can you keep the state's own investigation out?
I've never seen anything like it, and I have not seen much, but it seems, I doubt this has happened often. Like, it's weird. It's very bizarre.
Yeah, even if you don't have third-party culprit, third-party suspect, you don't have enough of a direct connection. Indiana calls it a nexus, apparently. Even if you don't have that, and the judge says, I'm not going to let you point to his roommate, or I'm not going to let you, make direct statements, arguments that it's the roommate or a specific other person. Never ever seen being limited to go into, did you check out the roommate? Did you bring the roommate in for questioning? And people that followed the Karen Reed case, it's the same thing. Preliminarily, state brought a motion in limine to keep out anything about people in that house and third-party culprits, what they call it in the Commonwealth. And she did it like every other judge I've seen. I don't know enough on the evidence yet. Were you planning to raise this in voir dire in opening? No, not really. Okay, I'm going to reserve ruling. You put on the evidence, and then before asking the questions, you approach the bench, and I'll let you know if I've heard enough of a direct connection for you to be able to raise third-party culprit. And yeah, but you're absolutely right, Michael. I've never seen where they've gone in and said, we're not going to let you question the investigation, show the bias of the investigation. it's it's a fundamental part of defending somebody accused of a crime is being able to point to problems or bias in the people investigating that crime. And if you can't do that, go ahead.
I think you have to make a distinction between what Brad and Andy can put on in their case versus what they can use on cross. Now, if they can't use this stuff on cross, then you've got a serious Sixth Amendment problem because you don't get to confront the witnesses against you. And I just don't know how it stays out, but I'm just scandalized that they can't use it in their own case. I mean, you have all these statements against interest.
Whether it's cross or in your own case, never seen a judge limit that anything that went.
What I'm saying is that there's a constitution. There's no constitutional. The constitutional limitation on putting it in your own case is the due process clause, the right to put on a defense. Plus, you're only limited by the evidence rules, and I think the evidence rules and the case law, this stuff absolutely should come in. But that said, there's a bigger limitation on what the judge can do with respect to cross, and that's the confrontation clause.
That's true. And the evidence rules, the way they're written, federal and those that track federal rules of evidence, I think Indiana does to a great extent. Texas does. Bias is usually listed as the number one area you can get into for purposes of impeachment. And not only is it impeachment, that's one of the top listed exceptions or reasons, ways you can impeach somebody is to show their bias. And there's, at least in Texas and some other states around here, that's an area you can clearly go into the bias of the investigation, looking at particular people, not looking at particular people, having tests done, not having tests done, incompetence of labs, failing proficiency, all of that stuff. It's pretty much black letter law, at least here, that not allowing somebody to go into that is reversible error here. Now,
well, I mean, under, as a matter of the evidence rules, it's only reversible error if it's harmless, and that's a lower standard than state law harmlessness is prejudice to the substantial rights of the defendant, whereas the violation of the confrontation clause is harmless beyond a reasonable doubt, which means it has to have not contributed to the verdict. You have to be able to say beyond a reasonable doubt it didn't contribute to the verdict. So, and that's right. You start with the evidence rules. I mean, and I don't think this is just a question of bias. It's a question of destroying on cross the state's investigation. Holman, I think it was, saying, I think it was Holman, and somebody can correct me, but yeah, I have no idea who that Odinist professor. I mean, I have no idea who that was. Can't find him. Don't know. I mean, Seriously, folks?
Right.
Um,
No, I
anyway,
agree.
but
And
I just think,
Perlmutter is clearly going to be in their case in chief, but cases I've seen, not being able to put somebody on to explain that their the investigation was flawed, not necessarily a particular individual was not pursued or is a viable suspect, but um,
well,
disallowing something that
I mean, in what world are Rick Allen's 61 admissions, as you call them, admissible, but the admissions of other people aren't?
well, if you're if you're trying to use it to point to a specific person being the perpetrator, it's a problem with that. But it's easily enough to fashion. You interviewed people that um, confessed, admitted, and you don't mention them by name until you reach the threshold of a direct connection. But it's always
The
been fair
initial,
game to say you had we had a big case here in the late 80s, early 90s called the Yogurt Shop murders, and three teenage girls were murdered and then burned in a yogurt shop. And it went cold, and um, coerced confession, and it's one of the first cases she testified in anywhere in the country, maybe a second or third after West Memphis. But the that was a death penalty case, capital murder. Um, 5 different people confessed to that, and they were just batshit crazy. That's a technical term, um, and confessed to this crime, knowing that if they were convicted, they very likely face the death penalty. And unlike some other states, in Texas, we really do carry it out, and some of our elected officials are almost proud of the fact of the number of executions that occur during their term. But in any event, um, those confessions were these people had come in and confessed. All of that was admissible, and the detectives had to go through and show why those people were logically eliminated. There's no way they could have done it. Now, the other big thing that happened in Yogurt Shop is 2 of the defendants were severed from the one who confessed. And the judge in that case, good friend of mine, the law wasn't as clear as it is now, but he allowed the confession, those statements, to be used in the trial.
did I lose you all?
Hello.
Well,
I'm here. I'm gonna run out really quick with my dog, but I'm here. I just, yeah, I'll be super fast. Are you still here, Travis, or did you drop
Yep,
off?
yep, yep. Can
Oh,
you hear
okay,
me?
perfect. Yep, gotcha.
So did it surprise you that they started with a certification for interlocutory appeal versus just going straight
Yeah,
to an original action.
Certifying orders. No, they had to do an interlock first.
Because there's a couple of other issues that you felt they had pretty strong grounds. I think one was you were up to 5 things last time I heard you talk about it that Gold did that she had absolutely no authority to do. And I think I heard you say that you felt that there might be some pretty good grounds for original action, maybe on bias or.
Well, yeah, but they filed their recusal motion, and I thought that was, they left the best stuff out, and they included some stuff that was just silly, and they decided not to pursue an original action or even an interlocutory appeal, and that's their call. I mean, they didn't raise. There's stuff they didn't raise in their recusal motion that just, and putting the letters, all the letters that Gull got, saying she was biased and how. I mean, that's never going to go anywhere because then you can just start a letter writing campaign to get rid of any judge you want. I thought including the letters was an incredibly bad idea. The one thing they left out that's just I can't get my head around is the fact that they denied she denied them a Franks hearing, but offered Libreto and Scremin one for the ass.
Yeah, and I think we keep forgetting about that. I do.
It's just and holding the criminal trial. I mean, with the law in front of her, that she can't do a criminal trial of Brad and Andy inside Rick Allen's case, and she does it anyway.
Well, based on her decision, she apparently read your footnote. Oh, man. Best footnote of all time. Have you tracked or looked at the defendant's motion to exclude the tool mark evidence? They filed that motion, and then it was summarily denied 7 months later. The state didn't even file a opposition to it. Have you looked at that at all?
I haven't, and it's kind of it maybe should have been set for a hearing. That's the kind of thing where you're going to have. I mean, the fact that it was denied without a hearing, that kind of motion to eliminate. Yeah, she should have set that for a hearing so they could get the experts, so that they could, show it was crap. And on the other hand, it's very funny. I mean, the standard's very low in Indiana for expert testimony. I'm not even sure there is one.
Well, according to that Daubert is just a guiding principle, but even in that case, the court was apprised of all of the problems with tool mark evidence and recent studies and the PCAST report and all of that. But that case involved the matching of an unfired cartridge with at where the person was staying, the suspect, with fired cartridges at the murder scene. And they pointed out a Texas case that didn't allow matching a unfired cartridge with a fired cartridge and coming up with the opinion that it was cycled through the gun manually. And they said, unlike in that case, we don't follow that standard. But it, at least they were apprised of everything pro and con, and it seems like they had some sort of gatekeeper type hearing. I don't
Yeah,
know.
but it's never going to be reversible error to deny a motion in limine. I mean, it's preliminary anyway. Dropped you. Yeah, I don't know enough about it. Um, I think they're going to have to do a bunch of voir dire on the state's expert. They'll have their own experts if necessary, and try and exclude it at trial. Did I lose you all? Hello.
I'm back. Hi, Michael.
Okay.
I think Travis maybe got disconnected. Oh, there he goes. Michael, can you explain what, I mean, maybe people don't need you to, but I do. Can you explain a little bit what you just said about voir dire?
So you get the expert on, and you ask them about their qualifications and ask them about the science, and then you might put your own folks on to say why this is crap, and it's kind of the jury's gone, and the judge has to decide whether the state's expert's going to get to testify or not.
So there's one thing that you and Travis said while I was outside. I wish that I had written it down, but you were talking about why didn't they raise the issue of Gull granting Scremin and Librato a Frank's hearing and denying them one, and they did. I don't know when they did, but I know that
I don't think they did in the recusal motion.
In the most recent recusal motion. Interesting. I feel like that can't be true. I'm not saying you're wrong. I would be very surprised if they didn't, because I know they did at some point. Because that was a glaringly biased thing that should have been like a no-brainer,
Yeah. And if I'm wrong, I'm wrong, but I believe I read it, and I remember being shocked.
Shocked that you didn't see it.
Yeah.
Yeah. I hope that we get Travis back eventually, but I mean, if not, that's okay. But I wanted to look at the safekeeping statute, Michael, if you don't mind, because they did say in this interlocutory motion they filed that there's literally no example or case law for this predicament, let's call it, in the state of Indiana. And I guess my first question is, I know where you fall on safekeeping in terms of Rick, but how do you understand the safekeeping law in Indiana? The requirements, the non-negotiables, the things that are up to the judge's discretion? Because my interpretation as a non-lawyer is that this is all very vague. And I would like to hear what you think. Oh, I was talking to myself. I need my volume up. Is that a thing? Oh, okay, Travis. Here comes the link. If my volume is bad, y'all gotta tell me, because I am blissfully unaware. Well, this is the safekeeping section of the Indiana Code. I am quiet. Is that better? Okay, here's the link, Travis and Michael. I think that is the correct one. Ron Logan had multiple .40 caliber handguns. He had 156 firearms when his home was searched, at least 2 weeks after the murders. As a felon. He was a felon. He had that many guns as a felon. Hi, Travis.
Sorry about that.
That's okay.
Wi-Fi issues. But is Michael still here? Because this was all his idea.
He is here now. Yes, we've got you both back.
Even if he doesn't believe it, this was his brilliant idea to come up with this.
Well, good. Michael, I have you, I can see you, but I don't know if you're back with us. But if you are, just...
I'm here.
Oh, there you are. Perfect. Do y'all mind if we talk about safekeeping really quick, since this is like my white whale? I am Ahab, and I can't let it go.
No,
your white whale.
Okay.
Yeah, love to hear about it, because I thought this was brilliant when Michael first discussed it. That he should have had an attorney, or at least been there.
Yeah, for sure. So I pulled up, I have a couple of, I went through the sheriff's motion, which, I want to start from the beginning. So, according, apparently, to Indiana's criminal code governing safekeeping, whoops, I went the wrong way. Upon a motion by the sheriff. That's weird. Alleging an inmate in a county jail awaiting trial is in danger of serious bodily injury or death, or represents a substantial threat, the court shall determine whether the inmate is in imminent danger. The court shall determine. If the court finds that the inmate is in danger of serious bodily injury or death, or represents a substantial threat to the safety of others, it shall order the sheriff to transfer them to another county jail or to a facility of the Department of Correction designated by the commissioner suitable for the confinement of that prisoner. For purposes of this chapter, an inmate is not considered in danger of serious bodily injury or death due to an illness or other medical condition. So the first issue that I see is like, is this a thing? The sheriff can file a motion.
It is not a thing, and
okay.
but the thing, and Travis is talking about Rothbury versus Gillespie County. This is where his custody is being determined, and he clearly had the right to counsel. This happened before. I think this happened. No lawyer had been appointed for him yet. He might have said he was trying to hire counsel, but he didn't have a lawyer at the time. No lawyer had entered his appearance. And this is Diener doing this. He clearly had a right to counsel. And the first thing a lawyer would have objected to would strike the sheriff's motion.
Right. Well, and then we see the inmate or receiving authority is entitled to a post-transfer hearing upon request, but it doesn't say anything about it, not at least not in this part. It doesn't say anything about a pre-transfer hearing, although I know that it says that elsewhere. But the inmate may refuse a transfer if the only issue is his personal safety. I have a feeling that they didn't give Rick that option, right?
I don't think Lesenby's motion even alleged any of the things required by the safekeeping statute.
No, it just said we're nervous. We're nervous that this is going to be hard. We're nervous that this is going to be unsafe. But there were none of the elements that were required. And then this is the only reason. So upon a petition by the sheriff alleging that the local penal facility is overcrowded or otherwise physically inadequate to house inmates, and another sheriff or the commissioner of the DOC has agreed to accept custody, the court may order inmates transferred to the custody of the person who's agreed to accept them. Whenever a transfer order is necessary under this section, only inmates serving a sentence after conviction for a crime may be transferred. So this wouldn't.
So, but that requires the prior agreement of the DOC, and Lesenby didn't get that.
Well, here's the problem with that, Michael. I have a text from October 28th, 2022, where Russ McQuaid states in no uncertain terms that he just spoke to Tobe Lesenby and that DOC is going to be housing Rick Allen as a safekeeper.
I understand, but what I'm saying is this part of the statute, and I can't see it, but if I understand the way you read it, it has that there has to be a problem with the jail, and there has to be already an agreement with the DOC.
Yeah.
And somebody has to have agreed to take him. And as far as I know, there was no prior agreement.
Right.
I'm it's a little weird. I'm coming back to me on a delay.
Sorry, I'm trying to work out my audio. See, I don't hear an echo, which means it's probably me, but I also don't have YouTube playing anywhere, so I don't know what.
Someone in the chat was saying that we were echoing, and I do hear a little bit of echo with Michael. I'm on my laptop now. I was on my phone before, so I don't know how I sound now.
Everyone sounds great to me, so I think I'm probably the source of the problem then, because I can hear everyone fine.
Michael, the sound on or maybe you don't even have YouTube up, but if you do have YouTube up, is that muted?
I don't have YouTube up.
Okay. Well, now you're perfect. So
yeah, it's gone.
Whatever dials you touched, Angela, you fixed it. So
no, I think you fixed it, Travis. No, I'm back. Now I've got an echo again.
Okay. Well,
anyway,
let's just persevere. So, Angela, I missed a little bit of that. Can you explain for me what you're pointing out here? That it looked like they violated the terms of the procedure.
Yeah, I'm really just kind of looking at the code, the chapter on safekeeping, because I hadn't before November of 2022. Like, I didn't even know this was a thing. And upon reading it, like Michael said, none of the elements for Rick in that motion that the sheriff filed, which, you know, whether he can or can't even file a motion is like, I guess doesn't matter because technically Judge Diener wrote it for him, but none of the elements were met. And there's also a section here where it literally says that the inmate can refuse the transfer if the only issue at hand is safety, like his personal safety. But he wasn't given any of, he didn't have an attorney, he didn't get a hearing, he didn't have the opportunity to object, and he didn't get a post-transfer hearing. So I just think that the most, like, his entire confinement was unconstitutional from day 1 to day 600, however many days he was there. So
Michael can talk about this more, but is there any of these rules that provide a procedure where an inmate under these statutes, emergency transfer of certain jail inmates, any under that title provide for either a hearing or an attorney, or does it just say that the court will look at these factors before entering an order? Does it provide for a hearing?
That is my exact question.
Okay.
Well, even if it doesn't, I say Rothgary requires one.
Right. So
it at least requires a lawyer. I mean, it at least requires a lawyer.
Yeah.
Oh, yeah. Right.
So those by themselves, I think what Michael is saying, that's not going to help much, except that if it's a critical stage under Rothgary, you have to give the defendant an opportunity to be represented by counsel. And these things could be pointed to say, if he had a lawyer, he would have been able to challenge the things you just mentioned.
Yeah.
And so it's important to that extent. The fact that they may have violated it or not, if it's not a critical stage, it's not going to do Richard Allen any good at all if there wasn't enough evidence about his safety, and Diener granted it improperly. It's not going to help him one bit. But if it's a critical stage and he was required to have a lawyer, that's what matters. Yes. At least that's what Michael told me.
Yeah.
In a chat. Yeah. So these things would be evidence of what an attorney could argue if it was a critical stage. It could be argued on appeal that, look, this is a critical stage, and if he had an attorney, these things could have been raised, that there wasn't a sufficient record to show there was a compromise of his safety, and then they would be able to show other things, that by doing this, it impacted the ability of defense counsel to defend him because of distance and time. Those are kind of ancillary, lesser things, but the key thing is to show that this is a critical stage. And I agree with Michael. Rothgary didn't go into what types of things are critical stages, but they did define much better at what point adversarial proceedings start, and it can be well before trial and include things like a lineup, being put in a live lineup. That's a critical stage, even if you're not under arrest, even if you haven't been charged yet. That's been held repeatedly to be a critical stage. And then after you've been arrested, for police to come and talk to you, interrogation, Miranda doesn't work after you've been arrested and you're in custody. They can't come and talk to you about the same offense and take another run at you, have you sign a Miranda waiver. Miranda's ineffective after you've been arrested and you're locked up, because that's a critical stage. So there's a number of things that the courts have said are critical stages, and you're entitled to counsel. You can't get around it with Miranda and other things. And then the big question is, they said, yeah, that was Miranda, and therefore he should never have been in that, that was a critical stage, and he never should have been sent to that prison. Then the thing's going to be, and I'll admit, in fairness to Michael, he said, I don't know about whether all of the confessions, if it is determined to be a critical stage, and then you have these confessions over a period of time, he phrases it like good appellate constitutional scholars
do. He said, I think there's a very good argument that could be made. And it sure made an impression on me that all of those confessions are, in essence, fruit of the poisonous tree.
Yes.
So.
Absolutely. I feel like it's, I as a layperson with no experience trying defending or anything, a case, obviously, like, but I can't think of how that, like, how does the state get around that because of how many, so I don't know if you've seen this, Travis, I think I may have sent it to you, but if not, I will. But this is just I thought I could zoom in more, but this is a timeline we're working on because of how many contradictions and, you know, vague.
Yeah, a really good timeline needs to be produced in this case. I've not seen it. I'd love for somebody to share that with me, so I could give you all some input on it.
Absolutely.
And maybe I'm not up on the facts of the case, especially the time period between February 13, 14 of whatever, 7 years ago, I guess we're going, and when Richard Allen was arrested. But, you know, I'm not up to speed on the facts at all. And I just know the general things. And yeah, I'd love for you to share that with me at some point.
Yeah, I'll email it to you. Oh, let me get Michael the link again. But the reason I bring it up is because, I mean, it was helpful just to lay it out like this because, like, so we were able to figure out that Rick wrote that letter throwing himself at the mercy of the court, begging for counsel at least before November 1st, because the first post stamp is on November 1st. And yet he's begging for counsel on probably the 31st of October. And then all of this violation of due process occurs between then. None of that would have happened if he had an attorney. He wouldn't have even they wouldn't have been able to even get him to DOC, in my opinion. So, I mean, brilliant on their part, but so illegal. Like, I don't see how anything that occurred within DOC, if they continue to push the issue of fruit of the poisonous tree, which I think they, like, that to me is the biggest issue here. I don't see a way the state can get around that. Like, he shouldn't have been there, period. You know?
Right. So, you know, and Michael's just so much more eloquent at explaining the way these legal issues work in the real world in something like a interlocutory appeal. And it's so he mentioned a little bit earlier. I don't know if he's still here or
I just sent him the link, so he should be soon.
But he mentioned a few minutes ago when he was having some right before the technical issues, is that if you don't raise it, and I think he said something about, you know, a good lawyer would have come in and done, oh, Michael's back, so I'll let him finish the thought. But he mentioned on some of these things that, you know, the lawyers need to come in and say, we got a major problem, and the problem is he's there illegally. And so in other words, if the issue isn't raised back, but can you give me a couple of key dates before Michael responds to that? What is the date of Richard Allen's arrest? And what is the date of his letter to the judge begging for a lawyer? Why can't I hear Angela? Can everybody hear Angela?
I've been muted. I'm so sorry. I was muted for all of that. I'm so sorry. Okay.
We were going to let you go on for 10 or 15 minutes.
I know.
Before we said anything. I just felt so bad. I couldn't live up to the agreement.
Please interrupt. no, you have to interrupt me. It's I have no idea if anyone can ever hear me or see me or anything. I have no idea if I'm echoey. Like, y'all need to keep me on my toes. My producer's gone, so
everything's fine.
Okay, so he's detained on the 26th of October. Charges are filed on the 28th of October. He has his initial hearing on the 28th of October. Sometime between October 28th and before November 1st, because his letter is postmarked on November 1st in Indianapolis, he authors an undated letter sent to the circuit court pleading for an attorney. It's sent from White County Jail, and that letter makes a very interesting, the trajectory of that letter is really concerning because it's postmarked in Indianapolis with U.S. Post Office on November 1st. But so safekeeping motion filed the 3rd of November. Judge Diener orders Allen, still without counsel, transferred to DOC on the 3rd, or maybe it was the 3rd, I think. Okay, sorry. Motion for safekeeping is filed technically in the evening of the 2nd. Judge Diener orders Allen to DOC without counsel November 3rd, then recuses himself. November 3rd, Rick's at Westville.
Yeah, I mean, I think that's all that's relevant. He didn't have a lawyer. I mean, it's over.
So, Michael, Angela's question, I don't know if you heard it or not, but she asked, how on earth can they get away with this? And while we were waiting for you to come back on, I mentioned that you had said a little bit earlier that it should have been raised, but I'll let you answer the question.
So should have been raised? No, I mean, I you said I had this brilliant idea about sort of global suppression because of it. I actually don't remember that, but the idea I know I've had all along is that it under Rothgary and a few other cases it ought to be an automatic second trial.
Can I ask a question? I've got a question about this
interlocutory
appeal, just because it's something that's kind of, I think there's probably a lot of sentiment that, maybe Gull just denies certifying this. And you said that, well, the next step might be to do another original action. Do you think that they would only just do the exact same thing that they're saying in the interlocutory appeal to take an original action, or do you think they might rehash the disqualification and just?
No, it's too. If they were going to do an original action from the disqualification, they need to do that right away. The delay on that won't fly.
Well, this would be another thing that they could add to it.
But they'd have to then go in front. They'd have to move for Gull to recuse herself, adding this to it. I mean, no. The answer is no.
Yeah, no.
So you think they'd have to do a third motion to disqualify before they did an original action regarding disqualification?
Well, third, fourth, whichever number it is.
It would be third.
And they're not going to get the time it was ripe. Way back when, and they've filed another one or two since then. They're not going to get the court. It would be summarily dismissed, and then, which is what 98% of original actions not involving lazy judge motions, but other type motions. Justice Rush just signs the thing saying this doesn't qualify and it's denied. No appeal, no motion for reconsideration. I've seen dozens and dozens of them, which was what made the first and second original actions so remarkable, is that they actually got
oral argument on it. And then if they did file an original action after denial of the certification, I think they're going to need a tremendous amount of help to get that fashioned in a way that Kara was able to, because you have to show it's non-discretionary.
Well, not after the second original action.
Well, the second original action did say that, you know, one of the things they were asking for was the disqualification of the judge. So, I mean, they wouldn't be able to, you know, there's been things that have happened since then that show additional bias, which is why they did file another motion to disqualify. You're saying that they wouldn't be able to go back with an original?
No, because one of the reasons, remember, when you look at that, the second original action, which, you know, the first one's about court records and access to court records and all of that PFD handled. But the second one about the removal of the lawyers, a lot of Kara's brief and whoever might have helped her with it was focused on the fact that there's no remedy. It's setting the case up for structural error, and it would just be a show trial. You can't say those types of things with respect to bias. That time is of the essence. You really do need to shut this case down until this new issue that hadn't really been addressed squarely gets decided. You can't say that with respect to bias. And just having more information than you originally had shows more and more that you don't have those factors that you did in the second original action that made it so compelling for the court to take it up.
Well, then let me ask this. So, like, just say, in any case, take this entire case out of it. If you ask the judge to disqualify themselves, you know, you ask them to recuse, you ask them to disqualify themselves, they don't. You ask them to disqualify themselves again, they don't. Is that just always it? That's the final answer, and there's no way that you can ever take that to the Supreme Court to remove a judge?
Michael would be better able to answer that. And we have a different system in Texas. The regional judge comes in and hears it.
Right, which makes a ton more sense because somebody ruling on themselves doesn't make a lot of sense. But
right.
That's the way it is here. So, I mean,
Yeah.
Is that the final answer, or is there like a potential, like, taking it up the ladder?
I mean, yeah, you can appeal it or file an original action, probably appeal, then an original action if the appeal is not certified. You know, basically, if everybody's favorite judge does something that is beyond merely an adverse ruling and verges on the outrageous, you know, they can file another one. I mean, frankly, I think the ruling on the third party guilt stuff's pretty outrageous, but it really is only an adverse.
I would agree. I think that's where I was kind of going with it. It was just that, like, you know,
it would look like you're just complaining about an adverse ruling, but you know, she does.
Well, they had a number of examples since, and you've even mentioned another one that, like, what they didn't even include is, and these are things that happened since it went to the Supreme Court previously. Like, there's a lot of things that have happened since then.
Just adverse rulings, I think.
No, but it's not just the adverse rulings, because she didn't grant them a Franks hearing. Like you said, that's something that hasn't happened. And, you know, there's, you know, I mean, I think they detailed it a lot of individual things.
Yeah, but they didn't move for, you know, they didn't move to recuse her right after that. I mean, you really got to,
there's not a timing, like,
it is.
requirement.
It actually is.
Absolutely is. That's the whole thing. The second original action, look how quickly they moved. First, they set up to be able to have a proper record with the first original action.
Well, I guess with the
and
timing thing,
immediately. And then once they were able to get the transcript, no, the timing on these original actions is ultra critical.
That's what I'm saying. The timing does kind of factor in here because, you know, Michael's saying, hey, this is outrageous as far as this ruling on the third party. And so they've followed the first step and done an interlocutory appeal on the third party. If she, you know, I think that you got some argument that, like, you know, the state filed one motion in limine and it was just, you know, rubber stamped, or no, the defense filed a motion in limine and it was just rubber stamped denied, no hearing, and that was it, no explanation, no hearing. On the other side, when the state files a motion in limine, it's a long drawn out hearing, and it was just granted rubber stamped across the board, you know, and now they've filed an interlocutory.
It wasn't granted and rubber stamped across the board. You know, she held hearings. I mean, I'm sorry, it's not
going to fly.
Well, no, I mean, it was granted in full.
Well, I'm fine. She held a hearing.
It's a distinct
she spent 3 days on it. She spent 3 days on it. Said she considered the evidence. It's going to be taken as an adverse ruling. I mean, I'm sorry. It's just the way it is.
I mean,
no, it's not going to. It's not.
She didn't grant. The defense also filed a motion in limine, and that motion in limine got no hearing. It just
look. Here's the deal on this. You see motions like this all the time. The judge granted all 194 of the state's objections, granted all 194, and denied all 372 of the defense objections. You see motions like that all the time, and they're disposed of in one sentence. It's not going to go anywhere. And if you want to get a OA really heard, what I think Michael's trying to explain to you is you need to focus on something that's timely and that is something that's mandatory, not discretionary, that involves a fundamental right, like right to counsel was in the second OA. The things with recusal and bias of the judge, they don't rise to that level. So you'd need to fashion something very specific, and then they could throw in that stuff if it was granted, but you're not going to mess around with bias and stuff you've taken 2-3 shots at before. You wouldn't risk that. You would just hone in on an issue that has a decent chance of being accepted on an original action. Because again, over 98% of original actions that don't involve clear-cut things like time limits on lazy judge motions, 98% get disposed of summarily. And when I mean summarily, Justice Rush signs a 2-sentence order, and no, it's really not viable. In fact, if they did have a viable issue on the denial of the motion in limine or depriving him of a defense, you really wouldn't want to confuse or cloud things by trying to go over old ground. I mean, it's
okay. So you think if there was an original action, it would directly just go to
It's like Michael says, it's
in the interlocutory appeal.
It's done and over with. There's nothing strong enough, because the things on recusal of the judge, it's not. They're not additive. It's not cumulative. So
the meat and potatoes of it were raised in the second original action. Then you did have major thing like the disparity in treatment of the Frank's motion by her chosen counsel versus the one she removed. But it's you don't get a new crack at it to the level, especially if you're trying to, like Michael says, use it based on the way she's ruled. You got to get away from that and show why this is setting the case up for either structural error or something that she was required to rule on in a certain way, but didn't.
Well, instead of jumping the gun, what do you guys think as far as like the chances of her certifying this interlocutory appeal?
I have no idea. I have no idea, but what I will say, and I got to get off. What I will say is that if the interlocutory appeal happens, one benefit of it is it will give Brad and Andy more time to bust the case. And I can tell you, I've been getting stuff that's been useful. I think they have, and I think the real answer here is that for Rick Allen to get a fair trial, the defense is going to have to solve the case.
Let me ask a totally different question, because it's just something.
Let me add something on that, because that was a great question. So I agree 100% with what Michael said, but I'm a little bit concerned. There was a local television spot, about a 3-minute segment. Can't remember which station, larger city, kind of their investigative news segment. Channel 8 investigates. Anyway, they got a spreadsheet from Carroll County on the expenses that they've been paying out. And they kind of went over in general terms how much was for additional attorneys for the DA, how much was, well, they had the person who's in charge of making sure there's enough security for purchasing the metal detector, so on and so forth. And they indicated that what they budgeted, he felt that it probably wasn't going to be enough, that they might need to get a little bit more from the county, and that they've expended a significant amount of money being ready for trial October, November timeframe, that they were going to probably go over budget a little bit because the judge expanded the trial from a certain 14 calendar days to, whatever. So I'm concerned she may deny it just from a fiscal perspective.
Right. And I think they did try to put that argument together as far as like it's going to be more costly to not do an interlocutory. But no, I see it from both sides.
Look, the money's not going to be a problem. We have Doug Carter on the record saying that the state has spent millions.
Surely they have.
Yeah, I mean, between the state police and the local law enforcement, and then you've got the FBI on top of it. Nobody's going to deny Rick Allen the necessary funds for this case. It's just not going to happen. And if it does, more reversible error. What can I tell you?
No, I didn't mean that not enough money to pay his lawyers or experts. That
type of stuff, but that it's going to cost she just seems to be extremely concerned about, for example, there's a line item that's attributable to the defense for jury questionnaires, which I'm assuming was the printing cost to print up 600 questionnaires. And, I don't know if those have gone out yet. I know they sent one set out already.
Well, I think the second set went out as well.
So, she seems to be real cost conscious, and oh my gosh, that we're going to have to print 600 more questionnaires. I see her denying certification based on, not overtly specifically, but I don't know. I just get the impression from her in the past it benefited everybody back when she in essence coerced or forced a motion to continue from the defense back in whatever that was.
Yeah, and so if she denies the interlock, then they go to they try the original action, and I don't know how it shakes out. I mean, yeah, that could certainly be a consideration of hers.
Okay, I've got those, since Travis mentioned that, I've got another new question before my first new question. Regarding the juror questionnaires, we saw a copy of the first juror questionnaires that went out, and they fully listed everybody that's on this motion in limine. And I would assume that since the second set of questionnaires, I think, has gone out as well, that they're probably the same.
Yeah, they would have been.
The motion in limine says you can't mention any of these people, but they sent juror questionnaires with all of these people listed on them. Is there this is almost from a state concern, since you got your motion in limine completely approved, do they have a concern that all these names went out on the juror questionnaires?
No, those names didn't go out on the juror questionnaires. It's just out in public, and they'll be addressed in voir dire.
Yeah, so they did have. Do you know Brad Holder? Do you know? Those names were among many names.
Well,
but there were questions.
50,
there were
half of them were the names that are on the motion in limine.
Well, there's a few, but there were also questions.
Every name that was on the motion in limine was on the juror questionnaire.
Here's where you're getting at. There are specific questions on that juror questionnaire about. Are you familiar with Odinism? Are you familiar with things related to?
But it was more detailed than that. They said, "Do you know any of these names?" And they included Brad Holder, Patrick Westfall.
Yeah, what they're trying to be, what Michael's trying to explain to you is that there's 30 or 40 names, which is standard. Every potential witness, was on there. So
no, it wasn't. It wasn't all.
I've got it. You're wrong on it. Okay, move on.
I'm not wrong because
You're wrong.
Names.
Pull it up and show.
I do have it pulled up.
All right, then move on. It's not an issue.
Well, it's not 40. It's 20 or 19 or 20. But half.
Are we talking about the spreadsheet? What are we talking about? Because I missed
about the juror questionnaire that went out.
Just on the questionnaire. Okay. Michael answered it. Move on. What's next?
Okay.
I don't know that I heard. I don't know that I heard it though. So you can finish your thought, Fiend, really quick if you want to, because I'm not really sure what we're talking about.
It's more from even a state concern. Is that the juror questionnaire that we've seen has a list of 19 or 20 names, and half of them are the names that are on the motion in limine that the state just got granted in full for them, that these names can't be mentioned, but yet they've already been mentioned to every possible juror. like, would they want to like remedy that some way? Like, because that seems unfair to the state when they've got this granted that these names shouldn't even be brought up.
Yeah.
Yet they've already been mentioned.
Right. Since
Like,
they
do you
waited so
want to
long.
redo the juror questionnaires anyway, or like, do you like, or do you want a motion? Does the state want a motion of like continuance to allow for a new juror questionnaire to go out that doesn't mention these names? Because it seems problematic that all these names are mentioned.
Among so many problematic things about the way that things have been filed.
That's the question. So, I mean, I guess we don't know.
So the state would be the one to raise that issue then if they had an issue with it.
Oh yeah, that I do mean that this would be something that the state would bring up. So, a completely other random question, not based on what is mentioned, is regarding the probable cause affidavit in this situation, because initially the probable cause affidavit was sealed and confidential, and all filings were like sealed and confidential, and there was a lot of hullabaloo about it. And eventually they were like, okay, we're going to release, do a document dump, and they released a redacted probable cause affidavit. But the probable cause affidavit, the redacted version that was released to the public, it's missing a page, and it's missing like information that I think is almost always included on a probable cause affidavit as far as what's made public. And as far as like, there's no date, there's no signature, and the name of the affiant isn't on it. That's the page that would have any of that information is just completely gone. So it's not that it's redacted, it's just this information doesn't exist in the public sphere. Is that something y'all have ever heard of as far as happening, especially like 2 years into a case, for the public just not to even have the probable cause affidavit or those pieces of information off of a probable cause affidavit? And like what would you do about that? Because it seems like it should be something that should be in the public sphere.
I've never seen it, but I'm a lawyer. I've never seen a lot of I've never seen a lot of the shit that we're seeing. So I don't know. Travis, have you seen that before?
Like, we have the PCA. We don't know who the affiant is on the PCA. We don't know what date the PCA is for. Like, it just definitely has never been provided to the public.
In federal court, you'll have sealed indictments. That's through a grand jury process, which they really don't use much of in Indiana. I've never had it in a case, but I don't know if the PCA was the subject of one of the things raised in the first OA, other than, I assume that was one of the documents that was part of the document dump. And they complained about that.
The PCA by itself was its own issue as far as it being made public, and they did the redacted version, but there was also the issue of everything else that was.
Yeah.
And then they did the document dump for that.
Yeah. So the PCA was the subject of a hearing, and it was the first hearing after the attorneys had been appointed, and that transcript's been obtained, and they said, they wanted to keep the PCA, keep it sealed. It was at that point in time. It was very early on in the case. It was the first hearing after Gull got appointed, after the Baldwin and Rosie got appointed. Everybody was
real cordial and very, very, very nice. You could even tell it from the raw transcript. And they said, McClelland said, we know there are others involved, and something pretty close to that, and that it would prejudice the investigation if the PCA got out. And the defense didn't have a problem with that at that time. And then, pretty much everything from that point's been up to the judge to do. And she had somebody, the IT person or whatnot, load those documents on a website or something. And that was part of the first OA. They said, that doesn't comply with the law. And then they also pointed out, they listed a few other examples. I can't remember if the PCA is one or not, but they said, here's a document that they've said, should be redacted, sealed, not released, but they haven't complied by filing the green sheet and doing these other things. But no, haven't seen that. But
well, you work with police a lot. Is there a reason why they wouldn't like? I don't think that there's a lot of information that's missing here, other than like the things that I'm kind of saying, which is like a date, the name of the affiant, and a signature from anybody. Is there a reason they would want to obscure who the affiant is on a probable cause affidavit? Because that's typically like a very important piece of information. Is like who is making this claim? Like somebody has to be making this claim.
Yeah, the defense knows, but the public doesn't. And normally that's why it's a public document, but somebody would have to make a request for an unredacted version, get the response, and then take it up through the procedure, through the that open record advocate, that office that they have, which is really good, by the way. But someone's going to have to press the issue,
right?
But the affiant is going to be, it's always one of the detectives on the case that's marshaling all of the information.
Right. I would assume that it was Tony Liggett.
Yeah, it's always somebody from the investigative team. In some states, Wisconsin, the investigator signs it, but then there's also a signature line for the district attorney, which we don't have in Texas. The district attorney looks over the real important ones, the big ones. They look them over, but it's always somebody who can swear to. They don't need to know all of the facts in there. It can come from other investigators. It can be one-sided to a significant extent, although omissions have been held in a few cases not to give judge enough of a clear picture, so it violates Frank's. But and of course, everyone here is familiar with that being pursued, and it was denied. But no, it's very, very unusual. But all of the stuff regarding the documents were unusual. They're so unusual that the first original action was filed, and the court's lawyer knew darn good and well that there were multiple violations and got the judge to fix it. So it essentially mooted the the original action. They cured everything in there, and then they tried to come back and say, well, no, we think there's still violations going on, and the Supreme Court disagreed and said, we disagree and we're going to dismiss, and then went on for 3/4 of the opinion to say, we remind courts, when they were talking to Judge Gull, that this is the way the Open Court Records Act works in Indiana, and this is what you need to do. And I don't know if those things touched on that or not. At the time, there was, you're supposed to file something with each document as to why, or the court's supposed to state why it remains under seal or why it remains partially redacted.
Well, there's something interesting. That's correct, and they did address that like pretty thoroughly with the first original action. Even though it was denied, they still gave that advisement on it. But there's a weird situation with like that initial document dump, is that there was a substantial amount of documents that were kept confidential and under seal, but there's no indication of what those even were.
Yeah, somebody
because they're not, because they never actually did follow that advice and like have like a supporting document that says this is why this is under seal, this is why this is under seal. Like, we don't even know what the things are. We just know that there are things.
Yeah, I remember that. And, I'm just, so somebody would, and I think that's part of what she was saying, that no, they haven't shown full compliance. And so you should hear this. They disagreed. And so it wouldn't surprise me at all if they never corrected that stuff that they were supposed to and didn't. So somebody would have to pick up the ball and make a complaint under the act, for anything to happen with that.
Will do.
I'm going to play this video again so that I think Boone is having some tummy stuff. So we're going to take a intermission for like 10 minutes, and I'm going to play this video again, and then I'm going to come back. And if you're both here when I get back, that would be wonderful. And if you're not, I will understand. Does that sound okay?
Bye.
I'll be here. What's the video about?
This is just a video that I made. I haven't posted it yet because I didn't finish it, but I'm going to play it. It's just about, what is it even about? I guess it's just about Gull and her order. And this is, I guess, before we found out about the IA. So I'm going to play it right now. And don't go away. Or you can. No hard feelings. But
Okay,
I will be back.
See you on the other side. Bye.
Having had the state's motion in limine under advisement following a hearing conducted on August 1st, 2024, and having heard and considered the evidence, admitted exhibits, arguments of counsel, defendant's supplemental submission regarding state's motion in limine, and the state's response to defendant's memorandum of law, grants paragraph 1 through 6 over defendant's objection, and grants paragraphs 8 through 12 over defendant's objection. As it relates to paragraph 7, the burden is on the defendant to show a nexus between Odinism, cult or ritualistic killing, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Ron Abrams, Kagan Klein, Jerry Klein, Ron Logan, and the murders of the two victims. The case law is quite clear that the nexus must not be based on speculation, conjecture, rumors, or hearsay, but rather on admissible evidence. The court finds the defense has failed to produce admissible evidence demonstrating a nexus between Odinism, cult or ritualistic killing, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Ron Abrams, Kagan Klein, Jerry Klein, Ron Logan, and the murders. Therefore, the court grants paragraph 7 of the state's motion in limine over defendant's objection. The court will not permit the evidence submitted by the defense in support of their arguments regarding third-party perpetrators in the trial of this cause, as the probative value of such evidence is greatly outweighed by confusion of the issues and its potential to mislead the jury. The court will allow that evidence to support an offer of proof at the trial if one is made by counsel. Jury selection will commence in Allen Superior Court October 14, 2024, with trial commencing in the Carroll Circuit Court concluding November 15, 2024. Paragraph 8 of the state's motion in limine reads, any reference to an investigation conducted by Todd Click, along with any reports or investigative materials from Click that are not relevant or used for the purpose of confusing the issues or has the potential to mislead the jury. Officer Todd Click's investigation into the Delphi murders paralleled and eventually merged with the investigation of Detectives Ferenczi and Murphy. It would be impossible to separate the investigative efforts and findings of these three law enforcement officers from one another. To exclude any reference to an investigation conducted by Todd Click is to wholly prohibit and erase the years-long dogged investigations of Detective Murphy and the late Detective Greg Ferenczi. Judge Gull's order granting the state's motion in full, without citing any supporting case law, and outright ignoring the mountains of evidence presented thus far in support of a third-party guilt defense, all but guarantees that the trial of Richard Allen, set to commence on October 14th, will be exactly what we've all feared but entirely expected: a practice run. While Judge Gull's bias against the defense attorneys and her shameless, uncomfortable coddling in favor for the state should come as no surprise by now, it is perplexing that the special judge is so dismissive of the defense's theory of the crime as being ritualistic in nature. After all, Judge Gull's own chief public defender, William S. Libredo, who was in fact briefly appointed to defend Richard Allen after Judge Gull committed structural error and threw his defense attorneys off the case against his wishes, has spoken publicly to news and other media outlets about his belief that the Delphi murders were ritualistic in nature, and that Richard Allen is more likely than not a factually innocent man.
I thought it was hocus pocus. I honestly didn't. I'd never heard of it, and the more I got into it, that's a real thing. It is a real thing, and it's scary.
In what way?
Well, I believe they sacrificed a girl and killed another one. Some of the people that live in Delphi were very brazen about their Odinistic beliefs on their Facebook pages, including the sergeant who was in charge of keeping Mr. Allen safe in Westville.
Sergeant Jones, who was wearing patches that said "In Odin We Trust" on his Department of Corrections uniform. Yep. The judge ordered the warden to make them stop. And then what did you notice?
That Mr. Jones had a tattooed under his right eye. From the best we can tell, it looks a lot like Odin's spear. And he had several tattoos on his forearms, including the interlocking triangles that are on his Facebook post. I got to give credit to Mr. Rosie and Mr. Baldwin that, they picked up on that. Confinement officers at the Allen County Jail aren't even allowed to have facial hair, let alone facial tattoos. I was a little miffed that the warden allowed that, or, he even knew what it was.
Do you have an opinion on that?
I do. I don't think Mr. Allen had anything to do with this. I honestly don't.
Is that something you say about all your clients?
No, and rarely do I believe it. But in this particular case, I believe it 100%.
If an Odinism defense is good enough for Judge Gold's chief public defender, and it's good enough for 3 highly respected and decorated law enforcement investigators who pursued suspects associated with Odinism for over 2 years, and it's good enough for the FBI Behavioral Analysis Unit, and for academic and forensic experts of the highest caliber and credentials, what makes Judge Gold qualified to argue? The former prosecutor of Carroll County, Robert Ives, has also stated that he believes that there were signature, ritualistic, and non-secular components of the crime scene.
The crime scene is very unusual. It's all very strange. If you had arrived at this crime scene where the girls' bodies were found, there were 3 or 4 physical characteristics of the crime scene that you absolutely would take pictures of. I hope that people who are handling the investigation will consider whether perhaps it might be time to release some more of that information. In the early days of this investigation, law enforcement, the FBI, the Indiana State Police, the Carroll County Sheriff's Department were looking for crimes in other locations that might have similar characteristics. And even then, the characteristics they were looking for tended to be more general things than the items I'm talking about, but they are very unusual.
You were quoted as saying that the evidence or the crime scene was odd. What do you mean by odd?
It was just not your normal, a person was killed here crime scene. There was a lot more physical evidence than that at the crime scene. And it's probably not what you would imagine, what people think that I'm talking about. And so because of unique circumstances, which all unique circumstances of a crime are a sort of signature, well, this unusual fact might lead to somebody, or that unusual fact might lead to somebody, where sometimes criminals will commit a crime in such a way that it's so distinct that it acts as a sort of signature for them.
Was there a signature in this crime?
I would say there were 2 or 3 things. I'd say at least 3.
Do you think those signature items would still exist?
I think potentially that 1 or 2 of those things could pop up again, yes.
On July 7th, 2021, at approximately 2:15 p.m., Detective Greg Ferenczi was shot and killed outside of the FBI Indianapolis Resident Agency in Terre Haute. A subject drove to the gate of the building and threw a Molotov cocktail at it. The man then confronted Detective Ferenczi and shot him as he came out of the building. Despite being wounded, Detective Ferenczi was able to return fire. An FBI agent also rushed outside and shot the subject, who then drove himself to a local hospital, where he was taken into custody. The subject was subsequently charged with the murder of a federal agent. As a pillar among law enforcement and citizens alike, the senseless, tragic loss of Detective Ferenczi shook the community of Terre Haute and beyond.
This is a federal case. The FBI will have the lead. Greg Ferenczi was a good man, a 30-year member of the Terre Haute PD, and worked in this community for many, many, many years. It's a sad day for this community and for the Terre Haute Police Department.
Greg was a 30-year veteran of the Terre Haute Police Department, but he was also one of us, a member of the FBI family. For 11 years, Greg served as a task force officer, later joined our Indianapolis Joint Terrorism Task Force. And to his FBI teammates, Greg was the guy. Greg was whip smart. His coworkers labeled him a secret genius. He was a terrorism expert working in the middle of the Midwest. Greg brought decades of investigative experience, invaluable wisdom, and life lessons.
The murders of Abigail Williams and Liberty German were the result of hatred. Hatred for women, perhaps. Hatred for race traitors. Hatred for the privileged, the elite, the other. But where judges are called upon to serve as a balanced, fair, and impartial foundation upon which justice may be carried out, Special Judge Frances Gull has allowed hatred to consume her. Hatred for the defense attorneys who were willful and insubordinate, who humiliated her in front of her colleagues and superiors. Hatred for her own shortcomings, her own inability to occupy a seat which she has claimed as rightfully hers. Hatred for a defendant who has yet to be tried, and despite his fundamental rights to due process and his total presumption of innocence, the the special judge held him in maximum security prison in total isolation and torment for over a year. Judge Frances Gull is on a mission. It's a mission she shares with the Unified Command Task Force, with Lieutenant Jerry Holman, with Detective Tony Liggett, with Prosecutor Nick McClelland, Superintendent Doug Carter. Judge Gull is complicit in the conspiracy to convict Richard Allen. We are watching the state of Indiana hang a constitutionally innocent man. The fix is in. And while the state of Indiana conspires to convict Richard Allen, the person or persons who murdered Abby and Libby are free. I'm back. Hi. Thank you for sticking
you are
around.
back. I was going to say, just leave me here with Travis.
I'm back. Yeah. Thank you for hanging out. I have a sick dog. He is being very demanding, so I appreciate everyone being gracious with my million interruptions and dropping off. So anyway, this is the part of the live where, oops, can't see me. Can you hear me?
Yeah.
Perfect. Yeah. That was great. Really, really good.
Thank you, Travis.
Excellent.
That means a lot. This is the part of the live where I restore a little bit of hope to some of the people in the chat who are feeling terribly depressed after our very, very helpful legal analysis. So, Travis, if you have some time to talk, hang out, I would like to ask you from, I know that you have, if I have a law enforcement question, I'm told you are the guy to ask as it relates to, well, is that true or not?
Yeah, typically, not always.
Okay.
Typically.
So, I guess hypothetically, with a case where there is, Karen Reed, for example, there was a lot of misconduct, maybe on behalf of the investigators, if not even illegal or unethical, certainly unsavory, the way that they were talking about her, all of that. So now we have the FBI kind of present in Canton, Massachusetts, doing what they're doing. In a case like this, where the task force has just, so you've got law enforcement violating rights, changing the story of the theory of the crime, which they're allowed to do, but just being, as I would say, very shady. What would it take? I mean, what kind of an infraction, let's say, would have to occur, or what kind of a oppression or infraction would a lead detective on a case, for example, have to commit for there to be any kind of actual investigation from an entity that can actually correct the issue and hold them accountable? And second part of that is how and what can that impact a case where the lead investigator has done shady things?
Oh, absolutely can impact the case. I'm sure that those text messages in Karen Reed's case had an impact. I thought it was really shady that they wouldn't have gotten those text messages though without FBI investigation. Typically don't ask for text messages between detectives on a case, because if you do, most discovery frameworks, statutes don't require that the state turn those over. But the other part of your question, what does it take? So immediately after the trial, after they got the testimony they wanted out of those detectives, even though they knew they were going to take a major hit. It wasn't then until they started their investigation, and even that detective's superiors, one was on the stand and others were in the text chats. They asked him, under investigation, and didn't say anything about it. They didn't start the investigation until after the trial, because if they started it earlier, even though they knew about it much earlier, it would have impacted the case. And there's really nothing you can do about that from a legal perspective, but clearly shady business. But what it takes to be able to prosecute a state investigator in federal court. I haven't seen anything. I saw a lot about the investigation of the case and them looking into the investigators, and then that related to what's the name of the girl who was murdered and the detective was recently.
Yeah, Sandra.
Yeah. How is that interconnected with the detectives on Karen Reed, or it's not? Is there any overlap?
I believe there's overlap, and I know that there's like bingo cards that people are posting where they have like all of the investigators that have touched Karen Reed's case, and I know that he's one of them. And yes.
Okay. Well,
but I don't know like how much, but he is. Yeah.
And remind me the name of the dirt bag that was doing most of those texts. And Procta. So Procta, it was really interesting. There was he had an FOP. FOP is Fraternal Order of the Police. He had a union association attorney in the courtroom, ready to instruct him not to answer if necessary. So did there was another witness. There was a detective that had an attorney standing right next to him, right next to the witness, in case he had to tell the witness, don't answer that. But there was a key question the defense was asking Proctor. They asked a couple of questions about the warrant.
It was Higgins. Brian Higgins is the one that had his attorney there.
Yeah, and so did Proctor, but Proctor's attorney was sitting in the gallery and was ready to stand up. But the questions about the search warrant and other things, they, said, I can't remember the specifics of it, but he was asked by Jackson, well, what about, if you had continued to search the phone, knowing that there were attorney-client communications, that would be a denial of her constitutional rights, correct? And he acknowledged, yeah, that would be. And then also he got into the warrants a little bit. So essentially what you have to show in order for federal court to be charged under federal law is that you intentionally and knowingly violated a suspect's rights. So it can't be something that's the subject of legal debate that, like most things are in a suppression hearing. I mean, there's suppression hearings all the time. Probably in every criminal court, at least once a week, there's a suppression motion on a statement, and the judge either grants or denies it. They grant it that it was, not voluntary, or it was coerced or whatever. Those police officers, they're not charged with anything, even though the motion to suppress is granted. And it's granted always because the defendant's rights were violated. And it's because the court's required to look at every suppression motion case by case. There's not any bright line, is what they call it. You have to consider all of the facts in the case, plus there's good faith exceptions and all kinds of exceptions that have evolved around confessions and whatnot. So the judge says, yeah, I'm going to grant it. It was obtained in violation of his rights. They don't go and arrest or charge that police officer, because the law on confessions, like everything else, Fourth Amendment searches, is constantly evolving, and court can look at it and decide one year that it's a legal confession, and then the law evolves and it's different. So it's got to be clearly illegal conduct, like beating a confession with a rubber hose or a phone book out of a defendant. It would have to be criminal conduct that violates their rights. And so clearly a made up probable cause affidavit in support of a search warrant, something like that, is what it's going to what it's going to take for the federal government, a U.S. attorney, to prosecute a state law enforcement official. Now, a federal law enforcement official, they can prosecute criminally. It's a little bit easier than a state law enforcement official, but you have to show an intentional, knowing deprivation of somebody's rights, and so that's going to involve clear, evidence planning, lying. Even though there's been a lot of egregious conduct exposed with exonerations, and the exoneration database that's kept by the University of Michigan, they track all of the exonerations, all the DNA ones, non-DNA ones, and terrible, egregious conduct. Terrible stuff in Chicago with detectives doing all kinds of crazy ass stuff. And either because so much time has gone by, like with the Chicago detective, over 100 people in jail over 20 years, that there's no way to go after them federally. But if they caught it soon enough. So even as horrendous as the conduct was that Proctor exhibited with those texts and whatnot, they would need something more to prosecute him in federal court under a official oppression crime.
And then
so criminally, it takes an awful lot. And then to fire somebody, it's super strong on the East Coast. They have real unions, like in Texas, for example. They're associations, because Texas isn't a big union state like the East Coast states are and the Rust Belt. But still, a botched investigation isn't going to get you fired unless they can show something intentional as part of it, intentional planting, something like that.
And does it have to be the defendant whose rights are intentionally, egregiously violated? Can it be someone connected to the defense or the investigation, for example, like a witness or an attorney or a family member or something like that?
Any citizen, at least where I'm at, any citizen who's been harmed by police conduct can make a complaint with the department about that. You have to go through their internal procedures. Now, anything criminal in Texas is usually investigated by an outside agency. The Texas Rangers investigate all police shootings, so that there's an independent agency reviewing whether the conduct is criminal or not. But whether something violates policy or not is typically done all internally. And so the citizen who has been harmed, but again, violation of policy, that's much broader than criminal conduct. And so, being rude being rude to a citizen on a traffic stop can get an officer in trouble. Probably can't get them fired unless they have multiple prior, allegations sustained on that. But in terms of a citizen complaint, that can be made by anyone that's harmed. Now, anything that's a violation of policy, which is don't use excessive force, don't be rude, all these different things that officers are supposed to comply with, including, don't conduct yourself in a way that would bring discredit upon the department. That's one of Proctor's biggest problems is, it's a clear violation of that. And every department has a policy: don't bring discredit upon the department, either on duty or off duty, either in your private life or your conduct while on duty. So some departments, getting a DWI is enough to get you fired, even though it's even if it's clearly off duty and nothing to do with your job whatsoever. But things like, for example, a police officer accidentally erasing video or audio, or even intentionally, those types of things really aren't the subject of internal complaints while the case is pending, because it's more related to issues in the case, like whether it's a Youngblood violation on destruction of evidence. So you really can't make a complaint as a citizen that somebody erased evidence in a case, even, if you're not the defendant. And if you're the defendant, can't really raise it as an internal complaint can only raise it as a constitutional violation and a motion to suppress. Did that answer your question?
Yes, but I have more.
Okay.
That did answer my question. So what about, DB's helping me, cases where an officer used state resources to oppress people, and then they didn't make a record of probable cause, and the oppression, well, actually, I'm not going to ask that. Just using your agency, your state agency resources to violate somebody's constitutional rights, like, more or less, is my question. What kind of recourse is there for something like that?
Well, most states and federally, there's a official oppression statute, and so we call that, and officers are prosecuted on this for all kinds of stuff, and judges also. Any public official can be charged with official oppression, but you're a public official, and that includes peace officers. And it's what we call a double intent crime. So you have to intend to oppress the person's rights, and you have to know that the conduct is just beyond the pale, that no reasonable peace officer anywhere in the state would think that that is appropriate conduct. So a lot of the official oppression cases, there's like judges that traffic court judges that trade sexual favors for getting tickets taken care of. They get charged with and usually convicted of official oppression, inappropriate touching and contact with a suspect, like a DWI suspect, female, and inappropriate touching. I mean, I've seen everything. Okay, I want you to do this field sobriety test, and clearly it's to get a better view of the suspect doing whatever they're having them do, and
Right.
so they get charged with. But in terms of using resources, I mean, usually that so much is it. I mean, it's so if a sheriff, this is typically if a sheriff has inmates wash his wife's car, which I've seen. Sheriff has inmates, trustees transport building materials for his brother-in-law, which I've seen. Having inmates and using those types of resources for personal things is get a lot of flack over that. People higher up, they have take-home cars, a lot of departments, and using those in a improper way, and get charged with that. Then in Texas, most other states, there's something called tampering with a governmental record, and that's where you alter a record. Something like you alter a lab report or a intoxilizer reading, get charged criminally for that. But the resources part, it's usually somebody who has enough rank that they can require subordinates to do something for that superior officer, nothing related to the job. It's, washing their car or, whatever it might be. So can be charged for, it's more rare. If you had like specific examples of that, I could comment on it further.
Let's see. How specific do I want to be? Well,
or we can save it for later.
Yeah. But I would like to return to this conversation in, say, 4 weeks. I think it will be relevant and exciting to talk about this again in 4 weeks. That's all I'm going to say.
Oh my!
What's in 4 weeks?
I don't know. I just feel like it's a good number. We have we have some specific examples. Yeah.
Well, we might have a busy 4 weeks.
You what?
That we might have a busy 4 weeks.
Yeah, we might. In what way? You mean in the case?
Yeah, and other things.
Yeah, just in general. Interesting. So what about like witness tampering? Or, one of the things that we've seen this week are these creepy weirdo stalkers online, harassing Kathy Allen, following her out of the courtroom, inviting her out to lunch, and then telling everybody that she went out with you when she didn't, and making up a bunch of stories to just like tampering, whether it's a spouse of the defendant, whether it's a defense witness, an expert, like how often?
I would get more specific because this seems like it's members of the media, even if they're non-traditional media, trying to like overtly get individuals to break a gag order.
I'm talking more, well, yeah, that. I think that I'm specifically thinking of law enforcement directly connected to the case, engaging in acts that a reasonable person would be like, that don't sound good or legal. Like, how often do you see witness tampering in criminal cases? Or how often do you see stalking and harassment committed by law enforcement, stalking journalists who are reporting on the case, stalking defense witnesses, stalking family members of the defendant, trying to get them to talk to you? Like, do you see that a lot?
No, I don't see it at all. But I mostly represent federal agents or police officers, peace officers, and so if we saw anything like that at all, I have the resources to shut that down immediately. But witness tampering pre-trial is going to be defense attorneys and prosecutors, where they have to be extremely careful on what witness tampering is. Pre-trial is telling somebody not to talk to the other side, or to disregard. You don't need to worry about that subpoena. You can disregard that subpoena. Those are that is witness tampering, and that can get you in a lot of hot water as a defense attorney, especially in family violence cases. What happens a lot of times is the alleged victim in the case is, it's going to be a spouse or a significant other, and they didn't even really make a complaint, want the other person taken to jail. But the standard for an assault family violence is any touching that causes pain. So it can be a pinch, get you arrested for assault family violence. And if you have a prior conviction, it's automatically a felony. So what frequently happens is prosecutor, for whatever reason, even though the alleged victim signs an affidavit, says, I want the charges dropped, those days are long gone, at least in Texas. And prosecutor can go ahead, and they think, no, we need to get a conviction on this guy or gal for whatever reason. They can proceed with it, and well, I'm not going to show up, and then the state does manage to get the alleged victim served, and then they call up their significant other's attorney, spouse's attorney, and says, yeah, I've been subpoenaed. What do I need to do? A lecture on this all the time. You have to assume you're being recorded, and you better say nothing other than you need to comply with the subpoena. Anything else is witness tampering, and is a crime, and is certainly going to get you in trouble with the bar. Then there's another crime, at least in Texas, that's called retaliation, making threats against individual because they've made a complaint, or they've performed an official act, like arresting a person, and they're in the back on the way to jail saying, man, you better hope you never run into me after I get out, or all kinds of threats like that. That's retaliation, and it's a felony. And then stalking is going to be tougher. Those are just more difficult, even in traditional settings where you have some nut that is following around a person, and or calling them 50 times in a row, or sending them 50 texts after they've been stopped. So in Texas, we've got stalking statutes that put kind of numbers on things, but they've had trouble, withstanding constitutional, but harassment from a police officer, following around witnesses or whatnot, those are going to be much more difficult to show, and you kind of have to let the attorneys know, so that the attorneys for that particular side, state, defense, whatever, can bring it up to the court,
to the judge. Yeah. Well, yeah.
But
Travis, what do you do if like a random person is doing that to somebody? Like,
well,
what if they're just getting harassed by just somebody that's from YouTube or Twitter or Facebook or something?
It's depends on what the harassment is. So,
well, I mean, the way that you framed it, where they're just like, oh, they text you 50 times.
Yeah, not too much. And you can, look at in the Karen Reed case, there's a side in the Karen Reed case that saying, yeah, we're, the subject of constant harassment, yada, yada, to the point where, they indicted that individual for harassment. But, you're going to have to get the prosecutor in that particular jurisdiction to say, you know, probably, well, I guess they did eventually after that incident outside the bar next to the pizza place. They did arrest 2 individuals that were touching his girlfriend. But, you know, you got to get the prosecutor. You got to document it in some way and get the prosecutor. And all of that was on cell phone video. And they did arrest those 2 people that were harassing him and his girlfriend. But the First Amendment, you know, it collides with the First Amendment. So it's much, much more difficult to get any type of official action, you know, one private citizen harassing another private citizen. It's just much, much more difficult. So you just need to know how to protect yourself and how to raise the issue. And like a lot of things, if you have a lot of resources, you can do that. You know, you can go in that court, different judge, but in that court, hire an attorney and file a temporary, you know, a motion for temporary order, temporary injunction, stay away. They call it a lot of different things, but again, that takes the resources of being able to hire an attorney and hoping that the other side doesn't have the resources to fight that. So you win by default. You end up with an order that says they need to stay a certain distance away and not have any contact or communications. And then, you know, YouTube stuff, of course, we've seen in this case, it's across the entire US. People are all over, not treating other people nice from, you know, several states away, and even countries across the Atlantic, you know. So it's
little Dutch trolls and whatnot. We've got them all, I feel like, in the now.
So, you know, it's much, much more difficult. And usually how that stuff gets taken care of isn't under harassment. It's, again, people with resources that can file defamation actions. But, you know, it's a lot of money. And so this culture that we're in with YouTube channels that, I mean, they, in my view, provide an invaluable service, for lack of a better term, in that, like channels like this one that do try and cover the, you know, law behind things and the rationale behind things. You know, it's educating people on the process, which is why, you know, I don't have a channel. I don't have anything to market, nothing to sell. You know, why are you on these different channels? Is that, you know, I've always believed the more educated people are, since we don't teach civics in school anymore, about the process, and seeing just how potential jurors that have never served on a jury before have no idea about how the process works or the way things should be. And I've always felt it's extremely important to try and keep people educated on all aspects of the criminal justice process, that false confessions do occur, that illegal arrests do happen, that investigators can get tunnel vision and be biased to the point that they totally screw up a case and arrest the wrong person. I kept, seeing it over and over and over and over again. And so
it's
that's
kind of interesting on the Karen Reed case. They had like multiple attorneys that were on the jury, and I think it was a former law enforcement officer that ended up being the jury, like the foreman. So they were people that were familiar with like the process.
Cops aren't familiar with the process. I've represented dozens and dozens who were criminal defendants. I'm
going to clip that.
They have no idea because they've never been a defendant in a criminal case. Depending on, y'all should be very, very well aware that being a licensed attorney in Indiana doesn't mean you know diddly squat about the way things work in a criminal courtroom. So did that ultimately get confirmed? I know that one Boston station was reporting very early on, before there was a verdict, that there were two lawyers, and then on the jury. And then I saw something later that nobody knows anything about these jurors, and other than it's what was it, 6 plus 3 alternates, 9, and it was they knew the split. It was 7 women, 2 men. So I know that they ultimately were able to talk to some jurors that were willing to come forward more recently. Did they confirm what some of the occupations were of the jury?
I don't know that that's been firmly confirmed. No.
Okay. Yeah, I heard the same thing. I heard the two lawyers didn't hear about somebody being an officer. That would be real super surprising.
It was also very coincidental that was the person. So Massachusetts is just different as far as choosing a four person, and the judge makes that selection, and she happened to choose that guy.
Yeah. Yeah, I heard that. She said, Mr. So-and-so, which told me, okay, well, there's at least one male, even though it's 7'2". And then I heard a general age of the...
was it not a 12-person jury? I thought it was.
No, it was 6, and I think plus 3 alternates. Right?
I don't know. I'd have to look it up. I always thought a jury was 12 people. Then I know that.
No,
I know that like whatever one of these cases was out west was a 6-person jury.
I may have it confused with those New Mexico trials.
I think it was the New Mexico one. I think that was a 6-person jury.
Okay, so I may have that confused, but heard it was many more females, and that they appeared to be all of the females were like 50, 60 plus.
Well, I mean, I don't know that. I mean, the demographics, like, sure, it's going to have an impact, but like, I don't think it's the most important part of it. Like, I think
all the research on that says you're dead wrong. It's critically important what the demographics are, the age, for example, whether they own guns or not, things like that.
I mean, yeah,
really, really important. And or
I'm saying that what's even more important than that was that their actual split on the verdict was, which that's starting to come out in the Karen Reed case as far as like what the actual splits on the verdicts were. And
it's not
it's
Some
not like
some of them appear to be
6-6.
outright acquittals. You know.
Well, no, two clearly look to be if the procedure was followed and the verdict form was better. No doubt the count 1 and count 3 were acquittals, but what was, I keep hearing the split. It was a 12-person jury. It was 6-6 on count 2. Has the split changed at all? I've heard 7-5 and 6-6.
I mean, I've heard more leaning in convicting. I think I heard more like 9-3 and like or 8-4, and then it was waffling between that it wasn't even. But more important than that, on the other counts, other than that specific charge, it was unanimous. Like there wasn't actually any doubt. So to not get that on the record seems completely crazy.
Yeah, it's real unfortunate. I've said from the very beginning, I can understand why the defense was high-fiving. They shouldn't have been. They should have. I've had where that exact same thing happened, and it's a strategy thing. And it's like, well, do we ask the judge to inquire how close they are? And if you think you've really, really got it won, then you do. But if you're not sure, you don't want to ask, because you don't want to tip off the other side that it's 9-3 or 10-2 for guilty. Now, when the judge asks, they don't ask which way. They just say, they ask without telling which way.
Well, that's kind of beside the point, because yes, that's relevant to that specific charge, but I mean, it seems the jury is extremely confused that they would deliberate on each charge individually and come to
the way
a unanimous
was,
decision on each charge, and they thought they needed to come to a unanimous decision on all charges, and they just weren't, so they didn't give their verdict on any of the charges, which is like completely bonkers like stuff. Like I don't know how they thought that, how the judge like didn't think to like clarify that. It's really,
or if there was 2 lawyers on there, how they let that go by. And you'd think 2 lawyers, one of them could grasp the fact that no, we can dispose of 1 and 3 and just let them know we're hung on 2. But it's a strategy thing, whether you want to know how close they are or not. Sometimes, you don't want to ask because you feel like if it's close, it's the other side's way, and you don't want to tip them off, because they'll say no, keep them going. I think I don't know. In hindsight, I'm thinking now the judge was just kind of like, well, based on this note, I've never seen a note like this. They're really hung. I'm not going to give them another depth charge, Allen charge. Their system, when we have multiple counts, I mean, we make it so clear. I write all of mine, and the other side usually accepts what I write, and it's almost exactly the way the jury charge was in Hannah Gutierrez, which
it was a manslaughter, and then a lesser included a manslaughter, and then the destruction of evidence about the cocaine or whatnot. And it was super clear. It was, what happens if you find guilty or not guilty, or if you can't decide, what do you do? And it was very well laid out on that. And, it's because I've had that happen where the jury sent a note out saying, we've reached a verdict on one of the counts, but we're hopelessly deadlocked on the second. What should we do? And judge said, "That's the note. What do you think?" I said, "Judge, tell them what the real rule is, that they should, if they're unable to decide on one, they should go to the others." And that's what he instructed them. And then they deadlocked, I don't know, a couple hours later, but it was murder. It was a police officer that was charged with murder in an on-duty shooting. And then there was a lesser included of manslaughter, and then lesser included of aggravated assault. And they came back and said, I understand you have been able to reach a decision on one of them. And he said, "No, we've all but one, we've reached decisions," and said, not guilty on murder, not guilty on aggravated assault, not guilty on this. We're hung on this other one. But it was laid out clear what they were supposed to do, but wasn't 100% clear if they got stuck on one of them, what they should do. Unfortunately, they had a question about it, but it was in there. They just didn't read it. He referred them. You'll see language. If you're unable to agree on this one, go to the others, see if you can reach verdicts, and, come back. But it does happen. And if you don't fix it right then and there, and send them back, or ask them, "Hey, how close are you? Don't tell me, guilty or not guilty. Just, are you guys far apart?" And you run the risk, if you ask the court, which is the way the Massachusetts rules work, that if you ask the court to inquire, so, well, we're 11 to 1, but it's and so then it's a big strategy thing. If the defense thinks, "Oh my gosh, it's 11 to 1 guilty, we need to hold out, we need the court to declare a mistrial, not give them another Allen charge." And the state the same way. So it's real strategic why you want to ask the court to make an inquiry, why you don't ask the court to make an inquiry. And that's their biggest problem on, have they appealed it yet? Judge Canoni's ruling denying that. Have they ruled on that yet? Have they filed an appeal yet? Or
I don't know if they have actually filed it yet. I know that they, well, maybe they did. Catastrophe would know. She says yes.
Yeah. So, I think I was watching Ali Mata talk about it originally, and she said, "Man, it's going to be tough to get around waiver," and it really is. And the way that rules written. It says the judge can, on its own or if asked, and people kind of convert that depending on which side, that, oh, the judge should have automatically done that. And when you have wording in a rule like that, that the judge can or either side can, responsibility falls on you. Otherwise, it's going to be looked at as a strategic choice. And I said, if it was reversed, the situation was reversed, and they had said, yeah, it's hard with those charges to make it work out logically. But if they had come back on count one, yeah, we were 12-0 guilty on that, and we were 12-0 guilty on count three, but we were hung on count two, which can't happen because count two is a lesser included of one. But anyway, the defense would be arguing tough cookies. You had the opportunity to request the judge to make an inquiry, and you didn't. So we're really sorry. Too bad. We need to retry the whole thing. And it's very, very unfortunate. Especially Jackson tried to get her to correct the form, and to her credit, she said, okay, yeah, you're right. But she said things like, I told you to get me I never let the judge prepare the form ever, because this is what happens. I always have a form saying, hey, here you go, because I've just been through it too many times, even in civil cases where there's alternate theories of liabilities defending doctors in medical malpractice cases, and there's can be assault and battery in a medical malpractice case if you operate on the wrong body part, lack of consent. There, multiple theories of recovery, and the verdict forms are similar. Do you find that there was an assault and battery? Do you find that there was lack of consent, informed consent, different things? And they sent out an inconsistent verdict that they found one thing but not the other. I've just seen it happen too many times, and the law's pretty clear. You got to jump on that stuff when it happens. But who knows? Given the crazy circumstances of that case, an appellate court might take a different viewpoint. But one last thing to say about that, I was with everybody, the defense experts on biomechanics and accident reconstruction and vector analysis, speed, black box, all of that stuff we use all the time in what I do, and familiar with it. And the defense experts were just, absolutely excellent, which is what you would expect the Department of Justice to hire in a case. I don't know what the jurors have said about, they're told that they were hired in connection with another proceeding, and it's easy to imagine.
Well, hold up, Travis. They weren't hired at all. The defense witnesses that did the reconstruction stuff, they weren't hired.
Yeah, they were hired by the Department of Justice.
Oh yeah, so they weren't hired by the defense.
Right. That's what the point I'm trying to make. They were told, the jury, that they were hired in connection with another proceeding. And then Jackson brought out, what have I paid you? And they said, you haven't paid us anything. And so the thing is what you know, it's easy to conceive a jury thinking that points to that they were hired by Karen Reed's insurance company to get out of paying the insurance claim. I mean, they could have easily
Gotcha.
thought
Yeah.
that.
Well, yeah. I mean, I think you can come to some different conclusions.
Yeah. So, and I just thought, oh my God, you know, so the defense really needs to be focusing on, as strong as their experts were. But you know, maybe it was a compromise, and they said, yeah, the defense with their experts have clearly shown this thing wasn't intentional. But I really think they raised doubt on intentionality by Lally pretty much showed that she, hysterical and, you know, so intoxicated, according to him and their retrograde expert. Retrograde is where you go back a number of hours to calculate what you think the alcohol was based on a alcohol test 5, 6, 7, 8 hours later. And
well, that doesn't really, I don't know. Like, just, I think it's just, maybe that's a me thing where, like, I'm not drawing the logical, like, connecting the dots as far as.
Well, you know,
I mean,
they were really quick on this thing wasn't intentional. And
I mean, you're saying the defense experts were strong, and the defense experts say it's impossible that this was caused by a car. Period. Anybody's car, not her car, not anybody's car.
I thought they were incredibly strong and much stronger than much stronger than the state's expert. What's his name? Trooper Paul. Is that it? Trooper Paul.
Oh yeah, that's Paul.
But you know, the thing people I think were overlooking is Massachusetts in the last 10 years has gotten super tough on drunk driving, and especially serious injuries or death with drunk driving. And there's a name of a girl killed by a drunk driver. Can't remember her name. Please forgive me. But, you know, it's some girl's name law in Massachusetts that if, you know, and that's why she was looking at, even under count 2, manslaughter by alcohol causing death. You're looking at, it was a minimum, can't remember, but it was like you had to, you could get 15 years, but you had to serve 10 of that before you could even be considered for parole. So that happened about 10 years ago. And
I mean, where people are killing people, I don't even think that's a bad thing. It's just the facts don't actually like support that that's what happened.
Yeah, so I mean,
the science doesn't support that's what happened. Like, you got like people that say the science just, it's not possible that he was hit by a car, and then you've also got other scientists being like he was definitely bit by a dog. I mean, those are my only 2 takeaways from, like, I don't know what happened, but those are the 2 things I'm mostly convinced of, are those 2 things. He was not hit by a car. He was bit by a dog. I don't know what happened, but like, whatever your theory is has to use those points of reference for it.
Right. And it's building blocks, and it is chess. And so they know they're experts, and, you know, they're using the government experts, and they know that they're going to conclude that, no, she, you know, what we're seeing here, that wasn't caused by contact between her car and John O'Keefe. And so you can't just go with that. Well, how does he end up dead in the snow? So they have to bring in that other theory. A lot of people were asking, well, why do you go so bold as to say he was framed? Kind of has to all, fit together. But fascinating case. But I hope, I really don't think the defense did as well as they could on graphs and charts and all of that stuff. I mean, they used some and they had some stuff, but I mean, we go all out because people, the studies on this are absolutely clear that, some people learn more through hearing things. Some learn more information from seeing things, but almost universally, if you combine the two, oral testimony and good graphics and good charts and good explanations, they retain significantly higher percentage when you do both. And I just don't, I think they could have done better on that, but who knows? The other thing I know for sure is you ask a jury after a verdict, what was the most, even if it goes your way, what was the most important thing to you? And they'll say something that, nobody even thought of, that, they really spent a lot of time on and was convincing for a lot of people that no one even covered either side. And, frankly, groupthink and these other phenomenon, Angela can probably even speak more to this. When you have a groupthink situation, you have dynamics like a older male, former military or law enforcement, can kind of control a jury. And depending on what side of things you're on, seeing the foreman come out and he's the retired Army colonel, or he's the, retired CEO of a Fortune 500 firm. It's like, oh, we got this, or, oh my God, we're dead, because they can sway people in certain things and get people to go along with their agenda, so to speak. So, I don't know, Angela, I used to think I derived a lot of benefit talking to the jury afterwards, but after doing over 100 of them, and later on, I'm more convinced of the fact that they can't tell you how they ended up reaching the decision that they did in a precise way, and you just have to trust in the fact that you covered all your bases to try and show reasonable doubt or tell your client's story in a positive way, and that ultimately had the impact. But juries are crazy animals. Go ahead.
I can't imagine. So I was just thinking the other day, like, I mean, there's literally nothing more or less predictable than like groups of people. especially groups of people who are of diverse backgrounds, ages, experiences in life. Like, I can't imagine having to come up with a strategy for appealing to 12 people who probably don't have much in common with one another. It's like I get like stress hives when I think about standing in front. Like, how do you could play it so many different ways? It just makes me feel like so anxious even thinking about it. And like, first impressions are so important that I don't know. I think that the state has really done a, unfortunately, remarkable job of keeping the Rick's defense attorneys in such a state of crisis with his detention situation, and keeping them, the discovery being so disorganized and so delayed, and just like, so like psychologically, right? As a therapist,
Are we Rick Allen?
yeah, sorry, I switched to Rick Allen. I don't know.
I want to jump in then because I got something to say.
We'll say it.
So I think there's a lot of like it was a huge a thing with everybody talking about this motion in limine, what the motion in limine involved, and what the denial of the motion in limine, and it was just the third party suspects. But kind of lost in the shuffle there is like the geofencing. Like, Travis, what do you think about that? Geofencing is a state tool used for prosecutions, like almost unilaterally. Like, that's the only thing that's used for. Like, have you ever seen like this where like the defense would want geofencing in, but the state wants it out, but it's literally their own tool?
I've never seen defense try and offer it. Geofencing and geolocation data was a pretty big part of the Telus trial over the murder of the reporter Jeff German in Las Vegas. And I kept pointing out in various chats that people who are interested in that related to Delphi need to go over and check that testimony, because the defense did have some points to make with geofencing, and they had their own expert that looked at that data and that phone, and there were a couple of things, 2 out of 20-30, but they were helpful to the defense. I don't know enough about the specifics in Richard Allen's case as to the nature.
Well, I don't think we have any of the specifics. Except that, I mean, the specifics that we have are that the state wants to keep their own geofencing like tool data out of it completely, if possible.
Yeah, and I have, the transcripts that were ordered. I don't know if there's more that are coming.
The transcripts matter that much because the motion in limine is order on, and the paragraph that says, I mean, any reference to geofencing and stop, like, that's out. It was granted.
Yeah, I don't know what his testimony was, or, and with Judge Gull, you don't know half the time why she's ruled that the way she has. She hasn't explained it, the normal way we get explained why.
I've tried to do a search on this as far as like any example of this ever happening before, and the answer that I've gotten is that there are no examples of this ever happening before. That the defense would want geofencing in, but the state wanted it out because, and it makes sense because geofencing is a state tool used for prosecutions. That is what geofencing is.
Yeah, it's difficult to say because I don't know what their expert, what the testimony was about it or whatnot. But I mean, if she's clearly wrong, then it's a do-over if there's a conviction, and that's a different type of expert testimony. That would be like, it's different than excluding the typical expert, which Michael's correct, absolutely. Getting a case reversed based on a court not excluding an expert's near impossible. But if it's forensic solid evidence and it's a DNA analyst, for example, and they've got DNA that points to a third person. DNA is found on one of the decedents that matches a third-party suspect, and there's no explanation for it. It's not a mother of the decedent, something like that, and they seek to exclude that forensic evidence. That is reversible. So it's just going to depend on how solid the stuff is that they have. Because there's dozens of geolocation and geofencing type data, and the experts in the Telus case were explaining that the data comes from specific apps, either Apple or Google, and you have to.
When it's referred to geofencing, it only refers to Google.
Not according to the experts in the Telus case. They're very clear. You can get geofencing from all kinds of apps. The one that they had was Google, and if you opted into that, and they said that's the thing that says, hey, I'm at this place, or checking in at whatever place. But they went on to explain, there are other apps that do that.
I think that's where it might get wishy-washy with like the word, like the phrasing of it, like the actual definition. Like geofencing is specific to Google and Google warrants. There's other
geofencing. There's other geofencing has nothing to do with Google. There's one, for example, they're a big telephone operator in prisons, Evercom. You can buy modules on Evercom and set a perimeter around a location like a prison, that who's visiting that prisoner, and you can enter cell phones into that Evercom module, and
it will text the lead investigator, for example, anytime one of those people on that list gets within a certain number of miles of the prison or the jail where they're housed. Law enforcement has many different levels of geofencing, and then the it's getting kind of aside, but geofencing is not limited to Google. It's limited to apps and programs that
Yeah,
have
I mean, I think it goes
capabilities.
to like what's historically been like realistic, because Google or Apple doesn't like hasn't participated in that sort of stuff, and Google has historically. They recently stopped because like there's a lot of problematic issues with being involved with this. But like, just because it's a possible thing, I don't think that that's actually what the reality of what anybody has access to most of the time, unless they're just drawing it off an app that they've extracted the data from like somebody's phone. Then obviously, then you have it. But I don't think that Apple really participates in those sorts of warrants as far as like any like established like history of doing that.
Apple Fitness is
well, again, that's where you could just have that data very easily from like a phone.
Yeah, but it's a combination of things like from Google, and like most people don't even realize, anybody that uses Google Maps, how they know the traffic is because part of the terms of service that you sign is that you agree that Google can track your phone anonymously. And that's how they're able to designate roads green, yellow, or red, is hundreds of cell phones traveling down the road. And
right, most people don't understand that you've probably opted into like Google,
right, but it with
stuff.
with traffic, and that, but it was great testimony. They talked about the percentages of people that use Google, and what percentage opt in to geolocation, so that geofencing can be utilized. But yeah, it was very informational. If anybody wants to know what it is, they had top experts in there talking about the history of it, what it will do, what it won't do. That Google is primary. There's some other apps that are out there that they may work with Google. I don't know. They didn't really go into detail about what the other apps, but any app that you opt in on that has geolocation can be used for.
Oh, if you're opt in, then that's like done deal. Like,
yeah. So
your phone is wherever you are. Like, if you've opted in, or if you don't know what that is, you probably are opted in. Like, so you probably are on that grid. Like, it almost has to be a very conscious decision to have an Apple phone and to make sure that you're opted out of like a lot of the stuff. Otherwise, you're just definitely on that grid. But unless you're committing crimes, not really that big a deal.
Yep. What else? So, Angela, the thing on the juries and the 12 different people and first impressions, that's where voir dire is so critical. Yeah. And there's a lot of
psychology in that. So, for example, might have a African American defendant in southern Mississippi, and the victim is Caucasian Anglo, and it's very heated, and you do want to know if what people's views are in terms of and they bring in 500 people and 480 of them are Caucasian. You're gonna want to know what their views are about African Americans. And so you never ask a question like, are you prejudiced? You do things like, have you ever known someone who was prejudiced? And you try and do it by questionnaire, so they're not having to say this in front of, even if they bring in smaller groups of like 40 to 60. And that's the way you have to ask it to get honest answers. It's just like, you never ask, you understand the defendant is presumed innocent. There's other ways you do it, because the state's already gone before you, and they bring that out, and they're like, yeah, we want you to presume them innocent, and so they're not going to say anything, and they don't want to say anything that they think there's right or wrong answers, and it's because the attorneys don't ask the right questions. You're trying to ask questions to really get to a deeper layer about how they see things. So you're doing more stuff about what their actions and their conduct in daily life. Where do you get your news? I watch Fox News every night at 6, or I watch MSNBC every night at 6. And are you on social media?
I would not trust anybody that watches Fox or MSNBC at 6 p.m.
That's
deranged. That's deranged.
That's why you ask, where do you get your news? And then some say,
well, they probably say, oh, cool.
I don't get any news from anywhere, and I just don't pay attention to the news. But those are the type of questions that you're asking, not the way you try and get away from what, other than, have you seen any publicity, read anything, newspapers, heard anything on TV, radio, social media about this case? And if yes, having seen or heard or read that, have you formed a conclusion about the case? We're not allowed to ask guilt or innocence, but typically the way things go, if they've read about it, the way things come out, they've typically formed an opinion on guilt. Not always, but
Travis, can I ask you something?
Well, let me finish how this information is, because Angela knows a lot about this. So you're trying to, and I don't know if this is similar to therapy or not, but you're other than wanting to know that head on, have you formed an opinion about the case? You're really trying to get at the way they think about and feel about certain things, because you want to know if they're receptive to what the defenses are. For example, in a family violence case or an assault case, how, does the defendant who used self-defense, whether it was with a firearm or some, striking back, do they have to be shot at before, how much threat do they have to have before they think it's appropriate to respond with deadly force? And you trying to ask open-ended questions, but that's one of the big things is you're always fearful of a wolf in sheep's clothing that's nodding in agreement with everything you say, and then turns out later that they have an agenda and we're against you from the beginning. But what do you think about that? That's how we try and get the 12, and it is like chess, because you want to bring out stuff that would be bad for you, but you don't want to bring out stuff that if the prosecution hears, they're like, oh, forget that. We're not keeping this guy on. So, for example, in this case, somebody said, oh, yeah, I know several people at my work that are involved in Odinism, and I think they're all crazy and they're violent and they're
oh no, they're probably cool. They're probably fine.
Nick's like, that's my juror. Or wait, no, he's like, I don't know, that's not my juror.
And so that's why you don't bring, you're not trying to help the other side, and it's a delicate balance. But so tell me a little bit about, and so you have these people, and the number one fear, I don't know if it's still the number one fear according to science, is speaking in public. So you have these people, there's usually 40s, could be 60, 80, talking in front of 79 other people about things. It's very, very difficult to get them to talk, but you have to get them talking because you need to know their feelings about things, how things sit with them. And if you don't, you never know what you have in the box. And I always feel like watching trials like Karen Reed, and about the only thing we knew is 9-3 or 10-2 women, 2 men. The women 50, 60 plus. Nothing about their education, whether they had science or engineering background to understand the experts. Nothing about whether they'd had a family member hurt or killed by a drunk driver. Nothing about whether they had a bad experience with Canton police officers in the past. And for me, watching these trials, I don't watch a lot of them, but I catch up through channels like this and other channels what's going on. But to me, without knowing who's in that jury box, it's like, it's a waste of time. But what are your thoughts on that?
It was funny because as I was listening to you and Michael talk a little bit about just like the jury selection voir dire process, I was thinking like, oh, it sounds a lot like, I was thinking that there are probably questions that as a therapist you ask a patient you're getting to know when you're trying to kind of suss out, there's like the problem that they come to you and they tell you about, and then they're like, what are you really here for, and trying to like extract that in a way that is without like fracturing the rapport that you're also trying to build simultaneously while you're asking them the most personal, invasive questions in the world. So I imagine open-ended questions, delivery, and eliciting just enough of an answer, but you don't want to elicit an answer for the state that is going to end up like, yeah, it just makes me think that they probably need like a lot more, this is going to be stereotypical, but like definitely need like women, a little bit more like human behavior psychology, maybe some social workers in the
Well, see, me and Travis talked about this before, and like what you're saying is exactly the opposite of kind of where we were going with that as well.
Well, tell me how then. Yeah.
Well, I think that there's like very important parts of like this case that are coming in. So like familiarity with like firearms is a very important piece of this, and potential familiarity with Odinism, which is extremely like 90% male. Like whether you even have heard of this sort of stuff, like I think you start going like in a very like unintuitive directions as far as your jury selection process.
Oh, and when I said like women and psychologists, I don't mean on the jury. I mean like jury consulting, right? Like the questions that are asked are so seemingly, it would be very useful to ask questions that are like a lot of cultural competency, going to be important. You want to understand the location and demographic and culture of where your jury is from. So I'm envisioning, we've read the transcripts of the Jennifer Dean trial that Nick prosecuted. And
I don't think it's that complicated, though. I mean, I think that they just...
No, it is that complicated.
You think that they're going to bring in somebody to help them with this? I think that
I could hope so.
Well, I mean, I don't think they're going to get that much help. I think it's mostly the attorneys working off the fly, and I've like heard a lot of people talk about this in the past. Like, and usually that's how it functions. Is the attorneys kind of just they're the ones that are there.
State's got experts on jury selection. I don't know if the defense does.
I hope, yeah, and I know they're expensive, but I think that,
well, no, you do want. We have the money for jury consultants. They really help you, and most of them have a psychology background. And, Dr. Phil was a jury consultant before he became Dr. Phil. He was Oprah Winfrey's jury consultant on that beef slander case in Texas. And, what the ideal juror is. Now, it doesn't break down like into one perfect juror. They classify things, but they bring out so much stuff it's mind-blowing. And the guy that's super famous that I use, his name's Robert Hirshhorn, and he's in Dallas area. And Robert Hirshhorn did the jury selection, was the jury consultant for Roy Black on the William Kennedy Smith trial, sexual assault in Palm Beach, Florida, which was about the first trial broadcast nationwide. And you guys are way too young to remember that, but there was a gray when she testified, the sexual assault victim, she had a gray thing in front of her face, and there was just a couple of things, but they showed the jury selection as part of that trial. And Robert Hirshhorn did it, and I've spoken to him numerous times about what were you trying to find, and it's just utterly, and then Roy Black's one of the greatest trial lawyers ever. If you ever have a chance to get one of his books, pick it up. But, just the things he brought out about, okay, it's a he says, she says, ended up on the beach, and, you got a Kennedy, and, after partying at O Bar, which was the bar in Palm Beach that they were at before they went back home, and how to handle this, and just and it's on any type of case. They're like, okay, I think this is the type of juror is going to be really, really good, and sometimes it may be older females, and when it's a murder and you got death of a child, it's fascinating to hear them talk about, okay, well, an older female is going to be much better than a younger female with kids, younger school age children in a murder case. They're just going to empathize too much. And then if the death penalty is in play and there's strong evidence of guilt, you want more people to be sympathetic to life without parole than death. But I mean, it's the makeup of people and helping out with jurors. It's just utterly fascinating. And in this case, I don't think gun owners, non-gun owners, are going to make a big difference one way or the other, because they're not used to seeing microscopic striations on brass casings. But people who own guns and are maybe Second Amendment supporters, strong Second Amendment supporters, could connect more with Richard Allen's rights being violated. And presumably they're going to get a jury question on, they're going to be charged with, were these admissions, confessions, voluntary or not? Michael Osberg has said in the past that there is a jury charge on that. We have it in Texas, that ultimately it's the jury who gets to decide that. If you have sometimes very conservative, politically, on the political scale, sometimes those are your best jurors when it comes to issues of improper police conduct in terms of how these admissions came in and whatnot. But no, it's highly complex, and ultimately you do come down to, if I'm on the fence, and what I use to decide whether I'm going to keep or use one of my peremptory challenges if I can't get them for cause is, is this the type of person I would go out to lunch with or have a beer with? You just kind of go with your gut. And because
that's my question.
Yeah. Yes. Ask your question, please.
Travis, are you ever able to take your lawyer hat off and just set it aside and just?
No. Not on here, because
no, not on here. Okay.
There's too many, people that will take something and run with it, and
it.
It's a conspiracy or
disclaimer things. I think you could just not do that.
Yeah, it's but
that's a good question, Pete.
Well, I mean, I have the same question for Michael. I'm like, can you ever take the lawyer hat off, like, and just like say what you think instead of like framing it in a legal perspective?
I feel like asking you to think about things as something other than a weird cat or a cat,
or just say say whatever you think, and just not like worry about like framing it in the legal like dynamics of everything.
I think that after having read the Jennifer Dean transcript, which is the only other, it was a felony murder case that Nick prosecuted, and Diener was the presiding judge. And I learned a lot. I think that it would be very helpful for people who are interested in the case to read these transcripts. I mean, they're public. I'll send them to you. But it was very interesting seeing, as somebody who I've had, interactions and experiences with both Judge Diener and Nick McClelland. And I have, my own thoughts about them, but reading their, these, oops, what did I do? Can y'all see this?
A second ago.
Where did it go? Nope.
All I saw was black.
Let me try again. Share screen. Did that work? Okay.
Yeah.
Okay. So we've got like
Can you make it a little bigger?
I sure can. Yes, I can. So, and I had like our notes, like our comments pulled up, but I honestly don't remember what I said while I was annotating this. Like, so I'm just not going to pull them up right now because they're probably like, it's just bananas. But like, you've got Nick McClelland here, right? So this is Judge Diener saying the objective today is to get a jury selective. We're going to turn the floor over to the state of Indiana and the defense for voir dire, right? Voir dire.
So in Texas, we pronounce it voir dire.
Voir dire.
And then
that's fine.
Other parts of the country, they put more French into it. Voir dire.
Voir dire and voir dire.
Voir dire is what I've
heard. Is that better, y'all?
Oh, I can read it perfectly.
Y'all, then you better say voir dire.
Okay, y'all, voir dire. So this is Diener saying, beginning with the state of Indiana through the elected prosecuting attorney, the floor is yours. Mr. McClelland, thank you. I think we should do a read through eventually. Maybe later this week we can do one because this is hilarious and terrifying. But McClelland's like, thank you, Judge, Mr. Manahan. Ladies and gentlemen, good afternoon. I'm glad we've gotten to the point that you're here. It's been a long time coming. I just liked this part. This is Nick McClelland, okay, in front of his Delphi or Carroll County jury, potential jurors. I'm going to be really honest. I'm a little nervous. It's been a long time since we've had a jury trial. On top of that, it's a murder case. This is as high as it gets in Indiana, right? We don't have a charge higher than this, so I'm a little nervous to be here. Is anybody else nervous? Nobody at all? I want to make sure I got the names right because we kind of switched people around. Mr. Appleton, is that right? And then he goes through asking.
So pause right there. So sure. Explain what he's doing there. It's the same as a therapist with a patient.
You're building rapport.
Right.
This is so like in therapy, a therapeutic method is use of self, right? So if I'm trying to help a person who's really nervous because they've never done therapy before feel more comfortable, I might talk about how awkward and
that's the whole point. The words aren't the most important thing here. Like, we know that he knows that.
Who, Nick?
Yeah,
right. He's good. Well, that's my point, is that so you wanted, use of self, and I'm just like you, right? I'm just like you all. I'm nervous. You're nervous. And it's just interesting. He's very folksy with this.
We all are. We're all from Indiana. We're all folksy.
But my point is that I think that some of the strategies or tactics or the persona that he puts forth, I'm not saying it's inauthentic, but the persona that is put forth here with this jury, I wonder if he will because he's clearly very comfortable as you read through this, which I think, I'll send it out. Y'all can read it. As you read through this, it's lengthy. There's like 5 transcripts and it's long and it's a lot. But as you read through it, I think you'll understand that, like, or you'll probably see he doesn't seem nervous.
No, I for sure want it.
Yeah, I'll just send the link like right now. But I don't think he's nervous. I think actually this is his courtroom and he's quite comfortable. In fact, most of the prospective jurors, like when you ask like, oh, it's okay to be nervous. We're going to get through this together. Okay. Like, this is the prosecutor and I'm the prosecutor and you're the potential jurors, but we're going to get through this together. And I'm on your team and I'm on your side.
Right. Team building. Yeah.
So, and again, I'm not criticizing the prosecutor here for once. I'm just saying that, like,
you also get like why like Andy Baldwin has this like very like strong principle of doing his mini opening statement, because he wants to do the exact same thing. He wants to build some rapport, like regardless of what you can or can't say, but like you want to be able to say something and like get your personality out in front. And like, I get that not everybody does that, but like it's not a bad strategy. It's a good it's a good thing to do. Like if you have positive personality, use it. You would absolutely do that any chance you get.
Yeah, and most people are quite, I think that people are pretty perceptive at the end of the day. Like, I think that watching the Karen Reed,
I wouldn't do it.
You what, Fiend?
But I wouldn't do it. I would just make every juror hate me.
Oh, yeah, right. Sure, I'm sure you would.
But no, what you've pointed out, if you could go back to that first one.
Yeah. Yep. Let me find
it. These are common things that are taught in prosecutor trial schools and also defense schools, obviously from different perspective, but he's bringing out, it's a very serious thing, murder, the most serious charge in the state of Indiana. I'm nervous because this is extremely important, but we all need to be relaxed and get through this together. I just thought it was really interesting. He did a really good job there of, even though this is the most important thing in the world and it's a super serious situation, it's okay to be yourself. It's okay. I mean, is that the way you read it?
Yeah, absolutely. He's totally, meet them where they're at. You want them to feel like comfortable, and you want to be very allowing and very, accepting but you also don't want to come across like disingenuous. So, I mean, that's why I think that Nick McClelland, like someone said in the chat, he was actually a public defender first in Carroll County. So he's lived there forever. His family's very, very like old Carroll County family. He's been practicing in the Carroll County courthouse for over a decade in some capacity. I mean, it's like he's probably slept there sometime. You know what I mean? Like, it's like his second dwelling practically. He's comfortable and he wants them to feel comfortable too. So, I mean, I'm very curious. I'm actually I'm going to use a word I have been using a lot this week because Libredo used it and now it's like stuck in my head, but I was like miffed that it's like he has home field advantage, even though the jurors will be from elsewhere. I think there's something really powerful about your environment and feeling comfortable in your environment and having home field advantage. And I just think being in that courtroom that he's so used to practicing in, having a job. Yeah, go ahead.
Is for both of you. So Rosie's from an old time firm. It may have been his father-in-law that started it, but or his father-in-law's father. Anywho, they represent school districts, a lot of really solid clients. But Rosie, to me, and I've never heard him utter a word through audio or otherwise or interviews. I've just read him off the paper. To me, he comes across more like Nick, and then Baldwin comes across to me more like big city Indianapolis. But I don't know. That's based on reading them off the paper. But how do you think they are?
Nick's not big city Indianapolis. He's small town.
No, Rosie and Baldwin.
I mean, Rosie definitely isn't. No, neither of them are. None of these people are.
Are you asking me how they present, like how I perceive them?
None of these people are Indian, like, or city lawyers at all.
But you're asking, Travis, how they come across, right? Like,
I don't think any of them come across that way. They're just all regular, like.
I mean, Hennessy. Okay, so they come across way different than Hennessy does.
Well, Hennessy's he's a league by himself. Yes, he's completely different.
My perception, I've only spoken to Rosie one time, and that was when I had to do a brief Zoom when Courtney and I were for the contempt that we didn't have to end up going, but like very quick, professional, brief conversation. And I found him to be very, what's the word? Clean, if I'm mature. He's very put together, but also I trusted him quite quickly. And again, I know I'm biased, but I just mean, like, I felt like, I believed what he said. I felt like I could kind of ask questions if I had them. So whatever energy he gave off was one that it was like not intimidating. I've never talked to Andy, but from what I've like seen and heard about Andy, especially when he's talking to the media, this is also true. But when I've seen Andy like talking to the press, at least like right after the arrest, before they were like gagged to oblivion, he was so transparent. Is I remember being like, oh my gosh, I believe this guy. He was saying things like, Rick is really confused.
What I was saying, like, we're all folksy, like that's like none of these people are anything different than that. These are all regular Indiana people.
Okay, so how then might that impact the fact that Allen County is a larger, more diverse, less rural demographic? How might that show up is what I'm curious to see. And I am, again, annoyed that the trial is going to be in Carroll County. I think that the environment and the setting, and I mean, the lack of public access in itself. Nick might as well be in a courtroom of 12 people because nobody else can get in to see it anyway. So it's like, it just feels skewed, and it feels, I just think it'll be fascinating from like a human behavior, and like just as an observer, I think it'll be very interesting. It'll be very fascinating to watch.
Andy Baldwin practices in a lot of different places. So like,
Ian, can you get closer to the mic? Because I can't hear you at all.
No, Andy Baldwin has a lot more like range as far as his practice. So like, I mean, he's definitely got more experience with that, but like by far the most experienced person with like diversity is Judge Gull. Like 10, like 100 times over any of the attorneys. Like, she's the one that's like actually interacted with a diverse like population.
Yeah, that's funny. She's convicted a lot of Black people. That's one thing about Judge Gull.
I mean, that goes towards where she's the judge at. There's just
kind of
different. I mean, it does.
Yeah, just the proportion of minorities that will be before her, but she's been problematic in the past. So I'll just leave it at that. That's my opinion. But I wonder if, so this is just why I can't even, I refuse to accept, I'm in such denial about the fact that thus far there will be no cameras and no recording and probably no transcript. Like,
well, I still would, I don't, I think that I wouldn't assume that there's going to be a trial next month.
Well, I agree with you on that.
And I wouldn't assume that she isn't going to
be the judge.
Well, no, that she isn't going to, like, if she is still the judge, that she won't put some sort of camera policy in place. But it will be whatever she decides under her terms, and nobody has any impact on that. But I wouldn't be surprised if she actually does it.
I can't see her doing it, and I hope you're right, and I refuse to accept that it won't. So I hope you're right, and I think people can surprise us. Certainly, if public pressure, I think public social pressure, we all want to be accepted.
No, I don't think that the public pressure or social pressure has any impact on her.
You don't think that a person with narcissistic
not for her
tendencies cares what people think about her?
I don't think she cares at all. I don't think she cares at all. I think she will do exactly what she wants, when she wants to, exactly how she wants to.
Right.
But that may include actually televising this some way, shape, or form. But it will be exactly under the way that she wants it to happen.
The lengths that Judge Gull has gone to, and the embarrassing, like, I would be embarrassed and humiliated and ashamed if I were her for the rulings that she has made, given her experience and her status and everything. It's like,
well, obviously that's why you don't want to show anything on TV thus far.
Exactly.
Yeah, but when you get down to the end of it, like, I mean, she might want to go that direction. I don't know that she will or she won't, but like I wouldn't rule it out at all.
I think Judge Gull cares a lot about what Loretta and friends think about her, and I think that.
Well, I already know what they think about her. like there's not a lot of jumping to conclusions here. Like, what do you think they think about her?
I think it's irrelevant.
They handed her the biggest case, and it's been a colossal fucking disaster.
It's not. I don't think it's relevant what they think about her. I think that they have up until where we sit today, they have done everything to protect Judge Gull. So even if they're
really just did one thing to protect her.
What?
I mean, they handed her the case. And then they did one thing to protect her, which was not throwing her off at the Supreme
That order
Court
was
hearing.
That was a big.
No, it was a huge mistake. But
yeah.
but that's just one thing.
So what about her getting? But then they appointed her to whatever the hell, like right as she's about to have her career is hanging by a thread, and they literally give her a promotion and report about it as if anyone gives.
I don't think they had any impact. They didn't direct that at all.
Broaden, my guy. I'm talking about like her peers, like her.
Yeah, but that's her peers, and like she does have standing among her peers.
Right.
Like, she has a lot of standing among her peers. She's a very accomplished judge where she's at.
Yeah, I know.
I wouldn't read anything into like her getting administrative duties.
I read a lot into it.
No. I definitely would not.
Why did I see it the same exact way as I see Jerry Holman getting promoted as his ass is on fire? It is.
Oh no, that's completely. It's like, I mean, it's just completely different things. I mean, it's not great, especially when the reality is like, I don't know what she's got going on, but she definitely does have some issues where she can't actually handle her own workload. So giving her more workload doesn't make any sense.
Yeah.
Whether she's deserving of it or not, like, completely different question. Like, and I think that, like, her entire history, like, I don't think there's anything weird about them being like, oh yeah, she should get this appointment. Like, I don't think it's that big a deal.
So I was told this presiding judge or whatever, I read the press release the same as you all did, but I was told that's a position that rotates, and nobody
That's
really,
correct. That more or less, that's right. Yes.
and that it rotates around. It's not. The press release made it like she was selected by.
That's probably more what I'm.
And I said, in our deal, everybody does a term as chief judge. Really, it's a pain in the ass. It's 10 to 20 hours a week more than what you normally have to do.
The whole problem right here is because, like, whoever the judge for this case should be, like that's the problem from the very start. Like, they should have had an actual special judge appointed to this where they could actually dedicate their time to this. And she is not. She's an extremely busy judge, and then she's taking on more duties. She doesn't give time to this case. Like, she didn't. Like, she can't handle both things. Like, she has another murder case with Andy Baldwin, and she schedules a hearing for him to go to, or for him to go to both hearings, but obviously he can't. He can only go to one of them, and she can only go to one of them. So she goes to one of them, and he goes to the other. Like, obviously she's stretched too thin.
Yeah, I think where the thing came down, where things really counted, is she put her hat in the ring once, maybe twice, as to fill a Supreme Court vacancy, and she never even made the cut.
Well, if anybody went to a Supreme Court hearing, they would understand why, because there's an extreme discrepancy between, like, mannerism and just, like, the way that they hold themselves. Like, it's an extreme difference in the way that they speak. I'm sorry, like, she's never gonna do that. She's never gonna be on the Supreme Court in Indiana. Never.
I agree with you, Fiend, and I think that kills her.
Oh, I'm sure it does.
Oh yeah, no, yeah.
She tried 3 times. The most recent time that she threw her hat in?
Better. She should like actually be better. Like, that's what she
Right,
should.
exactly. I mean, I don't blame them. I wouldn't want her anywhere near my Supreme Court if I were them either. But the most recent attempt of our judge to get on the bench was December 2022. So I think that there's always multiple motivations for everything. The fact that she's tried 3 times, she's been trying since 2006, I want to say, or 2011 was like her first. And it says a lot that she's not made the final 3, at any point. And the way it works is there's a committee. You put in your application, you do interviews, they weed out, and they get down to a final 3, and then they send those 3 to the governor, and the governor just picks one that he likes best. And Judge Gull has not been a finalist at any point.
I mean, I've literally watched Judge Gull sit in her chair and spin and stare at the ceiling like a fucking child.
Hey!
And like, no, that is not what the Supreme Court judges are doing. Like, they're extremely professional individuals, very intelligent, like, very educated, like, very well spoken. Is that her? No, not in a million years. It's never going to happen. Like, that's just not who she is. Not even close.
Yeah, I agree with that. I don't think that I think she probably very much so wants to be accepted by her peers, if you will. And I don't see it happening either. And I think that acceptance from them is very important to her, which is kind of what I meant. I don't mean like the general public. She doesn't even like, we're subhuman to someone like Judge Gull, but like in terms of like what they think of her, and if she looks bad in front of them, oh, I think she cares.
Well, yeah, but like it's too late now. Like she already made herself look like an ass in front of them.
Right now it's like, well, now she's just really going crazy because
they've already chastised her multiple times. We're going on 3 like very distinct times. Like we got the first original action, we got the second original action, and we've got the lazy judge order. And all 3 times she's been chastised for her conduct, like very explicit, like very plainly, like she was in the wrong.
Mm-hmm. Can y'all see this?
I don't think that they're happy with their decision to give her this post.
Well, they're not unhappy with it enough to correct it.
Well, the one time, that's why I will be very curious.
I know you keep saying that. I agree with you, but it's like,
what would happen a second time? What would happen a second time? But
how many times should they quit?
Michael and Travis say like there will never be a second time. So I mean, I guess that's just what it is. But I think that if it went back to them, they would take every opportunity to be like, oh no, like there's no way.
I know that there are friends of mine in here in the chat watching who, like myself, live a recovery-based lifestyle. And I just have so many times thought to myself, God, it would be so amazing if everybody did. I just feel like Judge Gull is somebody who could probably benefit from, like, I don't know, a little humility, a program where she has to work some humility into her life, maybe some personal responsibility. She's wild, man. And she seems to just get worse and worse as more time goes on. Like, you'd think she'd like,
I don't know. There's like, to be fair, like she's got a history of like not being completely terrible in like a lot of circumstances.
Sure, yeah, that's true.
But
then
there's definitely outside of this case, like inside of this case, like.
Well, I mean, she's done some amazingly horrible things, like putting a
terrible up and down. But
paranoid schizophrenic.
There's also random other cases where let's just like, no, that ain't it. That ain't it at all.
So I want to revisit this order of recusal, and then I'm going to end it because it's been, oh my gosh, really long time. But I'm going to end the live. Don't, like, I'm fine. State of Indiana. So this is the order of recusal that Judge Diener filed. Although it's not, oh yeah, it is. November 3rd. Very short and sweet. He says, the judge of Carroll Circuit Court has determined that the particular circumstances within the underlying case warrant recusal and dictate that a special judge be appointed in this case. The court recuses itself pursuant to, and then he cites a local rule, which I'm going to pull up in a minute. This court has determined that no judicial officer within the county may preside over this case. The court now certifies this matter to the Indiana Supreme Court for appointment of a special judge in compliance with, and there's the rule again, another local rule. So Judge Diener's reason for recusing himself is pursuant to this local rule. Let's see what it says. Because
don't read too much into this.
Fiend, I'm going to do it. I'm going to read into it, and I'm going to like it. So, local rule cited in Judge Diener's order of recusal. Pursuant to, this court has determined no judicial officer, blah, blah, blah. Okay. So then it's like, okay, I had to connect the dots. You get the local rule, and then they cite the state, the Indiana code. Okay, go with me. Don't, hold on. This is worth it because there was something very interesting that I want to ask Travis about. All right. So he cites this. This is what he cites as his reason. A change of judge. In felony and misdemeanor cases, the state or defendant may request a change of judge for bias or prejudice. the party shall timely file an affidavit that the judge has a personal bias or prejudice against the state or the defendant. The affidavit shall state the facts and the reasons for the belief that such bias or prejudice exists, and shall be accompanied by a certificate from the attorney of record that the attorney in good faith believes the historical facts recited in the affidavit are true. The request shall be granted if the historical facts recited support a rational inference of bias or prejudice. Does that mean so? Okay, so when I first read that, I was like,
so it's supposed to start from the beginning because it says state or defense.
Right.
So he could be prejudiced against the state.
Right. So did the state file an affidavit asking him to recuse because they thought he was being biased against?
No, because they don't have a signature. This is why I was bringing up the probable cause affidavit stuff, because they're...
Don't you think that's relevant, though, Fiend? The fact that it's not...
I do think the probable cause affidavit is relevant because I'm not familiar with any circumstances where a probable cause affidavit wouldn't be like, you know, people are saying, fuck you. It doesn't matter who is the defiant or the affiant in the probable cause affidavit. Well, I think it does matter.
Does this mean that the state officially asked Judge Diener to recuse himself because they thought he was biased against them, aka he wasn't doing what they wanted him to do?
I think that's completely possible.
Well, where's that affidavit? Do we not get to see it?
No, you don't get to see it. Absolutely.
Why?
Well,
he didn't have to say this one. He said this one.
There doesn't have to be anything. They can just tell that to him, like,
right.
You should recuse yourself.
Well, they can't though, not according to this.
Yep. And I'm gonna retire. And I'm gonna move to the Bahamas, and you're never gonna see me again. And essentially exactly what he did.
I wonder if the state got rid of Diener, if Diener got shit canned by his own club, because he didn't have to cite this specific one, but he did. The state or the defendant, but there was no there was no attorney for the defendant at the time, so the state may request a change of judge for bias or prejudice, file an affidavit, they have a personal bias or prejudice against the state.
Well, this is where it's important to get, this is one of the things that the baseline of this case is that a bunch of things still are held confidential.
Exactly. So let's read into them.
Have that list of things that are confidential, and we will have to file a FOIA request to make them produce what their forms that say that each filing is validly confidential, so we even know what those filings are, because they've never had to do that, even though the Supreme Court told them this is how it works. No, they still completely ignored that. Because they didn't produce that. But
are you curious what happened behind closed doors? Because I feel like we could figure it out, because he basically just told us there was a fracture.
I mean, we have to no. I mean, the answer is that we have to ask, and that's the problem. And it feels stupid at this point in time to be this delayed.
Mm-hmm.
But obviously the media wasn't going to do the very common sense things, and nobody should have really expected them to. But unless you do it yourself, nobody's going to do it. So that's the answer. You have to ask for the forms that detail each and every item that is made confidential.
Have you ever tried to ask Carroll County?
No, I've never asked them anything, because they're very busy, and I try not to bother them.
They're busy. They're busy, all right.
No, everybody asks them. So I've never.
They're busy, all right.
I never asked them for anything. I've never asked them for anything because everybody else is already asking them for stuff, and there is stuff to ask for. But things fall through the cracks, and this is something that's never been asked for. We don't have a list of what are the things that have been made confidential, and where is your actual filing that each and every item on this list is made confidential. That's what you have to specifically ask for. And you have to be very specific when you ask for things in FOIA type of situations, because the government is very adept at making things secret if if they can, they'll just do it. So that's the next step, is to ask for a list of the filings that make like expressly make these things confidential or sealed. And then by asking for that thing, you will end up with a list.
I think it would be,
it'll refer to which filings are actually confidential, and we don't have that list of filings that are confidential.
I think it's so interesting. Oh, I already sued him post-punk. It didn't. I'm not. It's someone else. I'm
You're right.
gonna tag somebody else, but Dieter said deuces. Wait, where'd that call? Dieter said deuces. YOLO. Fuck you, Ted.
No. I don't know that anybody is FOIA'd for any of this information, because
Sleuthy and I have FOIA'd twice.
What for what specifically?
Financial, public, for the budget stuff.
Well, see, that should already be public.
Yeah, right. I know exactly.
So that's.
She told me to kick rocks, kid.
Yeah. See, this is. Well.
Yeah, y'all requested it, and then
that is important, because
you requested it, and they said no, you can't have it. You got to talk to the
file a motion with the judge. Okay.
Judge, and then boom, the local TV's got the spreadsheet out.
Yep.
What's that all about?
I want to know that too, because
that's typically public information. I think they just made a mistake as far as maybe
they don't make mistakes there. Not like this.
They do make mistakes.
But they don't make mistakes. They don't make mistakes that benefit public access, is my point.
Oh no, they will. I mean, I wouldn't read too much into that at all.
Okay.
I think it's a completely honest mistake.
Interesting.
There's just not oversight as far as having some common sense of maybe I shouldn't have done that. That person doesn't exist. Nobody's actually giving oversight to any of this.
Well, my experience says that.
Well, it's not really. That's the thing, is that it's not that impactful, right? Because they paid Perlmutter, it's not going to matter. She's already on a transcript, and she's not even going to be a witness. At this rate. So where's the harm? Where's the harm done? I don't know. I mean, I think someone just wasn't thinking, and they're thinking, this is public information. I should release this public information. And they weren't even thinking about the ramifications that well, maybe some of this information should have been private.
Well, Beth Myers is the auditor. Beth Myers is the same person who, when the Hatch attorney called her, as an investigation would lead him to do, because he's trying to ask questions about grants. She literally said, does the Carroll County Sheriff's Department receive any federal funding or participate in any programs or offices that do? And she very confidently said, nope. And that was the end of the investigation. And then she immediately, per our sources, went to somebody's home to do something and told them outright, brazenly unashamed, I lied and said no. And I did not, I didn't, how did she say it?
Straight to jail for that shit.
Yeah, right. Just you can go to, of course, but it's not, my point is that this is the rule. It's not this is the rule there. They don't answer to anybody but themselves, and they will get away with it. And they're not worried.
There's a difference between releasing information and lying. It's just when she says I lied, yeah, you did something bad.
No, intentionally.
Like normally public information.
This woman's been the auditor for over a decade. She knows.
I'm trying to draw the connection of like what has been released in here that's actually like really substantive, like in a.
Oh well, I'm speaking more. I'm not talking about the contents of it. I know that could be problematic or not. I don't really. If it's public, I'm posting it because whatever, it's public. But should I have it? Probably fucking not. And the fact that for months, a number of us were really trying to get any information about the budget and the expenses of the trial, we asked her the exact same questions and got a totally different answer. And nothing had changed. The gag order is still in place. And
So what did change? Tom Webster asking for it?
I don't know. Maybe, okay. Finn, go with me. That's what I'm trying to figure out. Follow my logic. I'm trying to trace
Tom Webster.
No, Tom was not the first one to ask for it. The Wish, or it was WHLI or Wish or something, got like an exclusive, and that was not an accident.
They don't have an exclusive on anything. These people don't report.
Oh, Finn. You don't. So
they're exclusive.
The exclusive is what they were selected to get that and to publish it. And the news station said the auditor gave this to us. We didn't feel right publishing it like in its entirety, so we're reporting on it without sharing the actual document. So even the media was like, why did she give this to us?
Yeah, the segment said if you want to see all of the numbers and the documents, go to whatever it was,
Right. This is the same
and
problem.
I went there and they had none of the documents.
No, they changed their mind for some reason. I think
they had the documents. They're like, this is the whole problem with the state media. Like that they will facilitate the state leaking things and just be like, oh, whatever, but protect them.
Yeah, we're saying the same thing, Dean.
Do you feel good about that? Like, is that what you should be doing? You should just facilitate the state leaking things to you,
they don't give a
fuck. leaking information that is like definitely protected by a gag order. You should just feel like, oh, it's just a source. It's not a fucking source. They're leakers. They're leaking information to you.
Correct. Every single leak has been facilitated by the state. Period.
No, none of these people, whether you're like mainstream media or the non-traditional media, like that, if you're facilitating people doing that, you're the problem.
I agree with you.
You're both the problem. Like,
do you know that when the Hatch decision came down, meaning I spoke to the auditor, I did one thing to investigate. I spoke to the auditor. She lied, and I said, sounds good to me, because they closed that case on October 26, 2022. And literally, I lost my train of thought. Give me a second. Oh, before as the complainant, the person who launched the complaint, the person who's like entitled to information about the status of the investigation, I found out that a decision had been issued from Sarah Elrod Osbrook, who messaged me on Facebook, sent me a screenshot of the Hatch Act decision that she got from Tony Liggett, and threatened me with it. That's how I found out about it. So this is how these people operate. They don't. You cannot. This is why, and this is then I'm really gonna conclude. I'm so glad that they filed this interlocutory today. I've been raging about how Andy and Brad are objectively
raving.
Huh?
You said you wish you were raving?
Yeah, I said ranting and raving, and I meant raging. I said I'd much rather be raving than raging. No? Okay, let me finish. So, Brad and Andy are objectively superior litigators. the fuck out, TV. Yeah, fucking right. Superior litigators. They know more about, they have done a better job times 1,000 at defending their client than the state has been prosecuting. However, what I hoped, and I'm glad that it seems that they understand this, or that they're at least, anyway, if the defense is still going into this under the assumption and belief that having the truth and the facts and the law on their side and being superior litigators and superior in every way is going to help them, they have not been paying attention for 2 years. It's irrelevant. The truth is irrelevant. The facts are irrelevant. The law is irrelevant. How good of a legal argument, and I love Michael. I'm so glad we have him. He is like the Hulk. And we go back and forth sometimes because, you know, he has ideas about what would have been a better argument. And in my opinion, it doesn't fucking matter because she doesn't read their motions anyway. Like the fix is so in that if I were the attorney, and I'm not for this reason, probably, I would be going balls to the fucking wall like they did back in September of last year, because they can't get any less favor with this judge. Being staying within the lines and using the bumper guards as they've been doing has not helped them because they're the only ones following the rules. And if they hope that a jury will do its job despite a judge goal, and that there's any chance at all of a fair trial, even in like even a shred of justice and fair trial with Judge Goal on the bench, they should probably just not even bother. Like they cannot go to trial with this judge. Period. I know we've talked about that, Fiend, but like the system's broken. The deck is stacked. The fix is in. Nothing that they say or do, no argument, no case law, no legal precedent, no brilliant lawyering will fucking matter because it's decided. So I'm so glad that they are putting their energy towards getting rid of the problem, whatever it is, whether it's Judge Gold needs to be corrected or Judge Gold needs to be removed. I think she needs to be removed. The fact that she's still even embarrassing. Like, I would be humiliated if I had already ended up before the Supreme Court, barely stayed on the case. And she's like, it's like stranglehold. It's insane. That's my tangent. Like, the energy exerted towards preparing for a trial with Judge Gull is wasted energy. Rick's gonna die. That's how I feel about it. It's bleak.
Oh, don't get too dramatic.
I'm being dramatic by saying that the defendant who almost died could die.
No, I do agree with you because, like, hey, look how easy it was for Diener to just be like, okie dokie, like, I'll just file this and peace out.
Right.
Right.
So
right. Right. So
they
like, it should be just as easy for her, but it's not.
Right. Anyway, so I hope that I believe, and again, I wouldn't want to have to make this decision. It's like a Hopkins choice or whatever he called it, like delaying the trial for a few weeks or months in order to have a fair trial with an impartial judge. To me, it's not even a question as to whether a month.
Well, she did telegraph that she's not going to extend the.
Oh, I know. I mean, she's like, we're having this trial. She basically was like, here's my order on the state's motion in limine. I know that you're going to fucking hate it, but guess what? We're going to trial on October 14th.
Right, which is an insane thing to do because
100%.
The exact, like, the natural inclination would be like, oh, I'm sorry, like, I totally fucked up your entire case, so I should be
deal with it.
I should be open to like extending this trial, like if that's what you need, like I should be like amenable to that.
This terrifies me.
Exactly the opposite. Be like, oh, and fuck you, we're going to go to trial. Right. That's weird. That's a weird thing to do.
And fuck you. Well, she's weird, Fiend. She's a weirdo. I'm going to steal your word. She's a weirdo.
Weirdo.
Anyway, I'm gonna Irish goodbye. Travis, thank you so much.
Oh, thank
you
you
can
for having me.
anytime, literally all the time, anytime. And Fiend, obviously, goes without saying. You're just a squire and a gentleman and all the things.
Send me. You have my email. Send me.
I have your email. I'm gonna send you
Can
the
me and
timeline,
Travis
the
stay on
transcripts.
and talk to each other?
Huh?
Can me and Travis stay on and talk to each
Yeah,
other?
yeah, sure.
Oh yeah.
No, I gotta go too.
Oh,
Love to, but I got a
we'll just take it over tomorrow.
busy day job tomorrow. I'd love to, but tomorrow maybe. But yeah, thanks for having me on. I really enjoyed
absolutely.
it. And,
I'm gonna send you all that stuff, and
always
everybody in the
love
chat's
being
gonna
on
remind
with,
me because I'm asking him to.
Michael, that guy Footnote really knows his stuff without
He
a
really
doubt.
does. Michael's the reason that I'm on the he told me about the iPass. He was he's brilliant. Everybody, I think we have a lot of really brilliant people over here.
Oh, absolutely.
And also funny and so good looking,
Yeah.
It's lovely.
Well, thanks for having me on, and looking forward to seeing y'all again real soon. And I'll go over those documents and send you back some comments.
Please do. You're gonna love it. It's wild. It's a wild ride.
Great.
Okay. Bye,
All right.
everyone.